সমরিয়া এটা কি ম্যাটার হ্যাঁ ইনিশিয়ালি
এটা কখন হবে?
Yes, ma'am. On the last occasion, there was a direction to have instruction. There is awaited, madam. Can it be after 2 weeks, madam?
I am for the petition also. Whatever date may be fixed, which is an old matter here.
How much time do you require?
After 3 weeks, madam.
I can read
Okay. 51, madam.
the request of with understanding. Health.
Yes,
Which
madam.
have- which-
Health and NHM, both is there.
and the year fixed, they wait for the account. Another
No, no.
submit the date on the 19th.
Madam.
19th. Can it be on 20th?
20th, all right.
Madam.
20.
Deep to it.
May it please, my lord. Pay for requisition, we have filed one additional affidavit in item 50, my lord. I am for the petitioner.
Which matter?
My lord, Navadoti Sharma, my lord.
Item
Item 50, 50, my lord.
5. Have you served copies?
My lord, we have.
We'll have it listed on some other day. What is that?
My lord, that Kamakya
Item
Access
five.
Corridor. Kamakya Access Corridor.
All right. Item 5.
50, my lord. Allowed. Thank you.
May it please your lordship. Lordship, item number 17 and 19 are matters pertaining to division bench 1, lordship. In these cases, we have challenged the bias of the state GST Act. It's been wrongly listed before your lordship.
17 and 19.
19.
and the request. ID so
Bias of 16.4 of the state GST, AGST Act, lordship.
state GST.
State GST.
has been
16.4
challenged.
challenge.
What is it? Verify.
May I please your lordship? WPC 3403 of 2019. This matter may kindly list on Thursday. 6.
What is the subject matter? What is the subject matter? You're not aware.
I don't know.
You find out it topic. Find out and mention it tomorrow.
Okay, sure.
Item number 39, my lord. My lord, this is a matter pertaining to my lord, some construction was carried out by private parties towards my near to house.
39.
39.
Today is this.
Yes, my lord.
39 is the GST matter.
My lord, let me inquire. Sajan Kumar, I'm inquiring.
Trying for listing her application lordship.
Subject.
Land matter lordship, notification this week any date if possible.
14.
Okay.
Please your lordship. Kindly pass over the matter for the timing lordship. My senior is on the way and file is not with me lordship.
What is your name?
He is among lordship.
A. Zamar.
Yes lordship. For the timing lord.
Being agreed by. Hospital. Take it. We are issuing notice.
Briefly of lordship.
Wait, lord. My lord, the first order is at page 14, my lord. And the direction to this honorable court was page 70. This order was extended by page 18A, my lord. though there was a direction, my lord, that no third party right should be created, my lord, till the next returnable date. Subsequently, my lord, on withdrawal of the writ petition, the interim order was extended, and it was an inter-party order, my lord,
On withdrawal of writ,
on withdrawal of the writ petition, but the interim order was extended to 22/3/2024, enabling the parties to go to the appellate forum, my lord. But they have executed the sale deed on 5/3/2024 during the time when the interim order was in force. And it was an inter-party order, my lord, with a consenting order by both the parties, my lord. Page 18A is your last paragraph.
and it- that's all. One, setting, skip, skip, setting, and skip, what was the executed?
Registration of the sale deed, my lord, by 5/3/2022.
See, I
2024, page 24.
think it by writ, 4 weeks. Step two, by which
Highly great. So, Assam industry infrastructure development in order to expand some of their my lord, industrial area, my lord, certain land were procured. Now, my lord, based on that, my lord, a notification was issued on 9/2/2022. The parties, those who has, my lord, got the,
some instructions was
my lord, my lord. Now, I am coming to that point, my lord. There is an instruction that has been sought about the award, my lord. Now, my lord, the original file that we have, my lord, I have received from the department. My lord, the award actually lying in the entire record lying with the my lord, deputy commissioner office, my lord. We have only given the copy of that, my lord, amount which we have to pay. My lord. And it also, my lord,
government advocate.
the government advocate actually,
We have not yet received lots of any instructions.
highly required. I think that contain the entire thing, my lord.
According to him, that section for 64 is violated. The
No, but
limitation.
the second issue is very important, my lord. The court which is now dealing with the subject matter has no any power to, my lord, deal with the subject matter. There is a notification, my lord. The matter has to be dealt with by the, my lord, Kamrup Metro, my lord, not by Kamrup Rural, my lord. The next date is tomorrow, my lord. This notification, 27 May 2020.
Notification. What a development is there.
What is the grievance here?
The grievance is that, my lord, limitation is the core issue. Now, section 64 demands that in order to, my lord, make a case for reference, my lord, 6 weeks time is, my lord, frame thereon. But, my lord, neither it has been, my lord, placed by the, my lord, applicant, nor it has been looked into by the deputy commissioner, my lord. State by, my lord, in a very casual fashion, the application was forwarded to the authority concerned.
Proviso is also there, Lordship, in section 64.
My lord, lordship knows that the projects are, my lord, time frame, my lord, with a certain amounts, my lord, determined by the government. If
Have you
suppose-
extracted this section here
Yes, my lord.
in the pleading?
Yes, my lord.
At page 8, Lordship. Page 8 of the writ petition. And proviso is at page 9. Has your Lordship got it?
Yes. So the court wanted to see the award.
My lord, no. My lord, actually, there are a lot of correspondences from beginning to end, that different forms are there. Perhaps it would be like, my lord, before the deputy commissioner office, my lord, to maintain the entire record.
So you produce the record along with the award. Do it within 1 week. Then next Mr. Deputy will see what
My lord.
order we can pass.
Right.
Depending on progress of the matter.
Second
This
issue,
record of
my
this
lord,
LA case number, Lordship.
second issue is very important, my lord, that the Lamet Additional District Judge, my lord, Kamrup Rural, they have no power to deal with any subject matter.
We'll examine that.
But tomorrow is the date, my lord. That's right.
Tomorrow the matter is not going to conclude.
Yeah, absolutely. I just bring to your lordship notice.
H. Sarma.
Lordship, may I get a copy of that
Yes,
notice?
definitely.
H. Sarma. Sir, he had reported 75.
No, record কোনটো লাগে? LA case কোনটো?
Directed to a party. Right.
আচ্ছা, LA case 11 এ এইটো।
That's a memory award.
কিন্তু সেইকাৰণে অহা নাই নেকি? আমাৰ কিন্তু 11 টো খুজি পঠাইছে।
Agree that collector is vote 1. Right to pay compensation transparency. And execution of money.
একটা
It did not adhere a period of memory.
31 নাকি?
Next week,
Your Lordship is directing us to bring the record, Lordship. Next
we are
week,
asking you to tell us when the award was passed. Whether you want to do it by way of the record or by placing the award.
Lordship, Lordship, as because tomorrow is that election, that is why Lordship, may I pay some 2 weeks, if it is not inconvenient to your Lordship.
19th.
19th, Lordship.
The 3 and 4 connected case.
Your Lordship is asking for that award of that LA case number 5/2021.
Award is heading
5, 2020.
5.
Oblique 2021. Page
Lord.
30.
Lordship,
What about the second matter?
My lord, similar matter, my lord. They are different applicant.
Alleged.
Same, my lord. Applicants are different.
this 5 will do, Lord.
Lordship, may I pass over the matter for the day?
For the day.
Yes.
Prayer is made. It's that. Next.
May I please look? I came from the petitioner side and came before your lordship against the order passed by the GST authority, which is there at P8, page number 84.
Page number.
Page number 84, 78, no, 78.
Yes.
If my lords kindly permit, I just appraise brief facts in less than 2 minutes time, then I'll come on legal issues. Lord, I'm a automobile dealer of a Tata company, price dealer. What happened? GST department, state GST department has initiated scrutiny under section 61 on me. White notice dated 18/11/2021, which is there at P2. The issue was with respect to input tax credit. They have raised the issue. My lords may kindly come at page number 34.
Yeah.
The notice starts from page number 33. The relevant portion is there at page number 34, my lord. Not may kindly see that they have specifically identified that in the year 2018-19 and 2019-20, in both the year, as per them, ITC claimed by me was not correct. This case is in relation to 2018-19, so I'll focus on that one. So 2.22 crore, 2.44 lakhs precisely, was the amount which they asked me to clarify. But I have responded in great detail, which is there at page number 35. It's starting from page number 35. Then I explained everything that whatever you are claiming is not correct. The calculation made by the department is not correct. This is what the correct calculation. In a great detail, I have done that. And the correct ITC is, I have claimed correct ITC. Though, when I made that due diligence, I also found that in respect of 2018-19, actually, there was 30 lakh rupees of the credit, which was claimed by me in excess of the statutory. So I deposited that amount, which is, I have prescribed that mentioned at page number 36 itself, and my lords may kindly come at page 38. 38. I have deposited that 38 lakh rupees of the amount. Now, the important point is row number 4 at this particular challan. Just I wanted to emphasize this, that section under which voluntary payment is made is section 73, subsection 5. This is important. I'll come back to it at a later point of time. So for 18-19, I have deposited this much of the amount, 30 lakh or so. And after that, my lord, what happened? At page number 44, the department has passed the order, which is in form ASMT 12. For para 2 is relevant, my lord. Heading is order of acceptance of reply against the notice issued under section 61. Then the para 61 says, in this regard, your reply has been found to be satisfactory and no further action is required to be taken in this matter. So precisely, department accepted my contention that my input tax credit claim was correct, except that 30 lakh rupees, which I have deposited on a voluntary basis. Now, my lord, what happened? Once the department has accepted, and the acceptance was made by the Deputy Commissioner of the State Tax. After that, an officer which is junior to him, which is the Assistant State Tax Officer, has issued me a show cause notice directly without any kind of further investigation or any kind of investigation with respect to the input tax credit once again, which is there at P5, my lord, page number 45. A show cause notice along with summary of show cause notice, which is there in DRC 01, has been issued to me, again saying that input tax credit for the same year is not correct. Now, I have once again submitted the detailed reply on 7th August 2023 that whatever contentions are you are raising is not correct. Rather, I have claimed a correct input tax credit as per law. Now, nothing has happened to this particular notice even till now. This notice is even unadjudicated even till now. Just as a proof of this point, my lords may kindly come at page number 64.
This for which financial year?
18-19, same year, my lord. Same year.
Page 45.
Yeah, my lords may kindly come at page 4. My lords want me to come to?
No,
Sure.
you're referring to the
I'm
notice.
referring to 64 page, my lord. Page 64.
64.
Yes, my lord. So this is the show cause notice which I was referring, 7th August 2023. This is a snapshot of GSTN portal. That show cause notice was issued. I have filed the reply. It shows that I have just made a screenshot of page 64. And page 65, I have taken the screenshot that nothing has been done by the department till now. that show cause notice is still unadjudicated. I have filed the response in due time. Now, my lord, surprisingly, without even adjudicating that the second show cause notice, the department and the very same officer has issued me once again a new show cause notice for the same period, on the same issue of the input tax credit. A new show cause notice has been issued to me, or in fact, my lords, if I maybe, if I'll say so correctly, not show cause notice, summary of show cause notice. I'll come to it. So, my lords, may kindly come at page 66. For the very same period, 18-19, under the very same section 73, a fresh summary show cause notice has been issued to me in DRC 01. But this was never served to me. It was only and only uploaded on the portal, and I was completely unaware about it. And my lords may kindly have a look at it, page number 67. This particular summary SCN itself says date of personal hearing not applicable, time of personal hearing not applicable, venue where personal hearing to be attended not applicable.
Yes.
They have not given me personal hearing, and then they have uploaded a order in pursuance of the second SCN on the portal dated 28th April 2024. This is what the with which I am aggrieved, my lord. Now I am challenging these show cause notices and the second show cause notice and order dated 28th April 2024 on the multiple grounds, among which today I'll pose before my lords on 4 specific points. Number 1, this order itself is time barred. Number 2, there is a complete violation of principles of natural justice. Number 3, these documents itself are non-est. I'll start from one by one, my lord. First of all, my lords may kindly refer provisions of law, section 73.
Yes. Yes.
May I read, my lord? But first of all, it says, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax rate has been wrongly availed or utilized for reasons other than fraud, misstatement, or suppression. In that case, a show cause notice is to be given. The word used here is show cause notice, my lord. Now, my lord, it says in the prescribed form, in the prescribed manner. Now, the rules has been prescribed in Rule 142 in this regard. Rule 142, my lord. May I read, my lord? Rule 142, sub-rule 1 says, my lord, the proper officer shall, my lord, I want to emphasize here, it is mandatory, serve along with the notice issued under section 73 is relevant for me, a summary thereof in electronically in form DRC 01, meaning thereby what rules are giving, prescribing. When you are giving show cause notice under section 73, you have to give me a summary of the show cause notice in form DRC 01. Now, my lords may kindly come back to the impugned DRC 01. In my case, only summary has been served to me and no show cause notice has been served, against which the order has been passed. My lords may kindly come at page 66. 66 of the petition, 66. My lords may kindly see, this is DRC 01 under Rule 142(1)A, summary of show cause notice. Then there is an attachment to that summary. But again, some numbers, because there are some, they have to put it everything on portal. So they have issued me summary show cause notice.
This is what is prescribed under 140.
Sorry, my lord.
This is what is prescribed under 140.
So 142 says you have to give me show cause notice, and along with show cause notice, you have to give me DRC 01. So here it is only and only DRC 01, no show cause notice is being served. Now, my lord, this aspect has been already handled by multiple honorable courts. And they have specifically said DRC 01 cannot be a substitute of the show cause notices. If I may be permitted, Lord.
Yes.
But compilation which I have placed before your lordship is at page number 77 of the same. The identical matter recently has been handled by Honorable Jharkhand High Court.
You're referring to page 77.
No, my lord, 17. It starts from 17, my lord, of the compilation, my lord. My lords are there?
Yeah.
Yeah, my lord, if I may be permitted, may I directly take you to the relevant para?
Yes.
Page para number 7, which is there at page number 19. My lords are there?
Yes.
Now the law is no more res integra in as much as Rule 142(1)A of the GST rules provided that the summary of the show cause notice in form DRC 01 should be issued along with the show cause notice under section 74 subsection 1. The word along with clearly indicates that in a given case, show cause notice as well as a summary thereof both have to be issued. As per Rule 142(1)A of the JGST rules, the summary of the show cause notice has to be issued electronically to keep track of proceedings initiated under the registered person, whereas a show cause notice need not necessarily be issued electronically. The court in the case of Messrs. Nux Services Private Limited and so, they reproduce everything. And my lord, if I may come, may I request only relevant portion, I'll page para 17, which has been referred in the very same judgment at page number 21, my lord. As observed herein above, the impugned notice completely lacks in fulfilling the ingredients of a proper show cause notice under section 74 of the Act. Proceedings under section 74 of the Act have to be preceded by a proper show cause notice. Now, the emphasis would be there on, my lord, in 2 lines. A summary of the show cause notice as issued in form GST DRC 01 in terms of Rule 142(1) of the JGST rules and Exit 2 so and so cannot substitute the requirement of a proper show cause notice. Now, the conclusion is that there at the next page, para 11, my lord. We are of the considered view that the impugned show cause notice in both the cases do not fulfill the ingredients of a proper show cause notice, and thus this amounts to violation of the principles of natural justice. The challenge is maintainable in exercise of the writ jurisdiction of this court. Accordingly, the summary show cause notice dated so and so issued in form GST DRC 01. In both the cases, the orders dated so and so, and also the final orders dated so and so passed under Colonna Annexer are hereby quashed and set aside. This was, my lord, in an identical situation. Honorable Jharkhand High Court held. I have already explained, my lords, the relevant statutory provisions. If my lords may kindly permit, I would like to come to second ground challenging this particular order.
So, which is the judgment where the Jharkhand High Court has explained this?
Sorry, my lord?
Which is the judgment?
This is the judgment whereby they have referred the earlier judgment.
Where is the earlier judgment?
I have not made the compilation of it, though Honorable Court has already extracted the relevant portion in respect of in para 8 itself. All relevant aspects has already been included there.
Can you take us to para 8?
Yes, Lord. This court, in the case of Messrs. Nux Services Private Limited versus State of Jharkhand and others, passed in writ petition number so and so, in which one of us was the member, has taken note of the said provision of law and has categorically held that summary of show cause notice in form DRC 01 is not a substitute of the show cause notice under section 74 subsection 1. The relevant portion of the judgment is set out below. Para 13 of that judgment law. A bare perusal of the provision indicates that in case where it appears to a proper officer that any tax has not been paid or short paid or erroneously refunded, or where ITC has been wrongly availed or utilized, by reason of fraud or any willful misstatement or suppression of the fact to evade tax, he shall serve notice on the person chargeable with tax, which has not been paid or has been short paid, or to whom refund has been erroneously made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice, along with the interest payable thereon under section 50 and a penalty equivalent to the tax specified in that notice. In contradiction to the provisions under section 73 of the Act, under the same chapter 14 relating to demands and recovery, the ingredients of section 74 of the Act requires either of the following ingredients to be satisfied for proceeding thereunder. That is, that the tax in question has not been paid or short paid or erroneously refunded, or the ITC has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax.
Where is the summary of notice?
It is there, my lord, at P7, my lord.
Page number?
Page number is 66, my lord.
Yes. Okay.
Now, my lord, this is what one aspect, one ground is. Another second ground is, my lord, these all proceedings and demand has been created on me on the basis of non-S document. These document does not exist in eyes of law. How I'm saying so, my lord?
What are you raised today? Because this matter has come up for the first time.
Yes, my lord. My lord, I need interim protection, my lord, because demand has been uploaded on me.
What is the demand? Where is the demand?
P8, my lord, at page number 78. Yes, my lord.
Very well, we'll come back to you. Let us hear what the respondent.
Lordship, Lordship may issue notice, because I have to check the instruction. As to why repeated so-called notice has been given.
We issue notice.
My lord's interim protection is required.
Your name, please?
Jatin Harjai.
Well, is Mr. Beach or State Council of the Company? State is
For 1, 2, and 3.
1, 3. Petitioner is agreed by order. 28. What is the amount?
My lord, this is a tax amount is 4.68 crore along with interest and penalty.
4, 8, 7, 7. Along with interest and the penalty. The total amount of 10.29. Directing the petitioner by 28.5. Are there any subsequent proceedings initiated for recovery?
My lord, it is the recovery note. The recovery notice has been issued, which even says the amount is to be paid within 30 days, whereas law provides time of 90 days.
Past so this claim of excess claim of tax for alleged excess claim of show cause. There was no show cause notification, rather, summary of the show cause notification, which is contrary to the provisions related under section 1. Rule 1.
73, right? Section 73, that is rule 142.
Let me submit that proper show cause notice and no personal hearing was also afforded to the check that said the further claim, further demand that for the same financial year, the demand rates have already been
Scrutinized and assessed.
has been properly scrutinized, and the where is that order of the sir saying that
That is ASMT 12P4 at just a minute, my lord, this is at page number 44.
I ordered it in 18. But this is for financial year 1920.
No, 1819 and 1920 both, my lord.
Where is that?
My lord, kindly come to page number next page, my lord.
89. This is again a summary of show cause. 45.
Just my lords, kindly come at page 47. This is specifically says this month, January 2019, February 2019, March 2019.
No, you pointed out an order saying that no further action is required.
My lords, just
Where is that page?
that is ASMT 12. Just a minute.
Uh,
This is ASMT 12, my lord.
Page number.
Just a minute. My lords, may I request to come to page number 34, my lord, first? Or rather 33, if I may request, my lord. This is the notice which was issued to me in ASMT 10, though it mentions at the heading that it is for financial year 1920, in detail on the next page 34, it says 1819 and 1920. So my lord, there is an issue in system that they have to put in one particular year. In details, they are putting me 1819, this much of the amount. Then I have given response for both the years, 1819 and 1920, along with the amount which was required to be deposited. Then they have passed this ASMT 12 order, 18 January 2023, on page 44. Page 44, P4. They accepted my reply in which I have given both the years, 1819 and 1920. Due to some technical reasons, there might be the year pulled up was one only.
It's the 30th. I noticed dated
18th 11/2021.
11, and for which it was raised for financial year 2008.
Yes.
I would like and prices. Spotted for 551. Intimate that the reply could now that they did by subsequent notice reopened and for the same financial year without any order passed.
Yes.
Any other submissions?
This is one important aspect was there, that the order and the show cause notice both are completely unsigned. So these are known as document. Whereas as per Supreme Court, until unless the order or notice is signed, it is
It's submitted that both the order and the notice, demand notice. You're referring to the
demand notice, show cause notice, both are completely unsigned.
notice. When it comes to the stage, again, we'll make it 3 weeks. I think we can still again on 24th of June. In the next 6 next day. We are fixing it on 24th.
Look, I have some Gujarat High Court matter on that paper. Just absolutely different. Absolutely. Deeply obliged. But if I may just point out, I think it was wrongly narrated as Rule 143, whereas it is 143.
142.
It is 143.
You refer to 143?
No, I haven't referred a lot. I have referred only 140.
140.
Deeply obliged.
May I please, Your Lordship? My lord, last question, my lord, Your Lordship directed me to submit a copy of the requisition to test of the. I have submitted a copy, my lord, but they have not appeared, my lord. Also telephonically informed them, my lord.
It's you appear for Department of Housing and Urban.
No, Lordship, I am for item 7, Lordship. Yes, Lordship, 1 and 2. 1 and 2. Their names are not shown in the cause list. Officer Kushani.
May I have followed?
After the 3
But intermittent focus.
since there might be a right with the way back. Yes,
Intermittent focus notice may be kindly be
where is the show cause?
for demolition order, my lord. At
So-
page 53, my lord.
Huh? Page
53, my lord. 53.
53.
It's a so-called notice, Lordship.
And I have already submitted the reply also.
Till the next day. 147. Whereby, where are the show cause? Show cause notice for demolition. Yes. Seriously. Legal.
Lordship.
Obligement.
Lordship, kindly pass over time being.
Let notice go, man, this is. When it's to start to the last page of representation, not even sealed. Page number 16.
Neither signed or
Neither sealed, neither signed, neither sealed, the same representation. Page number 16.
You get your instructions, you see, the representation is at all pending.
No.
Third, that the petitioner was the possessor of box and entering that's by Dr. 99 down the Pelona and the respondent authorities on 28 giving the stated by
number 4. GMDA.
Four.
GMDA.
APA. 43. Yeah, no, it's not 1 and 2. No particular code. Because of the representation, it is going to find based on the report.
No.
Petitioner will serve extra copies, so the respondent copies.
That should also say, like he said that this land is a government land, but it has a pata number.
Don't know you find
Here this is petitioner with a very limited prayer request before this court, my lord. We are the legal layers of our father, my lord, Gajendra Bhumis, my lord. Our ancestral property where the Patta does, as without our knowledge, my lord, has been sold to the private respondent number 4, my lord. When this fact has come to our knowledge, my lord, immediately we made an application before the Deputy Commission dispute, my lord, and thereafter to inquire into the matter, but thereafter under no action on the part of the respondent authority, then again we file one reminder. Despite this second reminder, also they are sitting silent. So before this court, Lordship, can you have a look on my lord? Annex 1, page 10 first. The Jamabandi, my lord, our name is showing in the.
let us issue notice, let them find out status.
Yes, my lord. My only one prayer, my lord. That during pendency, my lord, since my two representatives are pending, if they wish to dispose of me.
Yeah.
120.
Steps of this. Right.
Page 14 and page 16, my lord.
Make clear that
My lord, deeply obliged.
please do.
May I please your lordship? Lordship, the petitioner is the owner and in possession of a private pond measuring 2 bighas, 2 kathas, and 9 leches. Lordship, the pond is absolutely a private land of the petitioner, part of which is Miyadipatta land. The petitioner is releasing hatchling in every year, spending a huge amount of money, lordship, and when the hatchling grow up, the petitioner used to sell them in the market. The pond is not the government fishery, lordship, and as such, the respondent number 7 to 10 have no any manner of right to catch fish or prevent the petitioner from catching fish.
File a suit.
Notice may be issued.
File a
lordship.
suit.
Was not filed, but complaint was lost. There. Complaint was lost.
Yes, lordship.
All right.
My lord, prayer person may be seen, my lord. Page 12. Second paragraph, my lord. And should not be allowed to embarkment his pond as well as fishing standing on a government land continuously adjacent to his Miyadipatta. He's admitted, my lord, that it's a pond is on government land. In fact, in paragraph 2 also, petitioner stated that it's on government land, just adjacent to his Miyadipatta land. So it's admitted position, my lord, that is in the government land.
You get instructions.
Yes, I'll get it.
Let them get instructions.
Yes, yes.
Date and embankment. I'll get fishing. See. PNR.
PNRD. No.
You know, status. In
2 weeks.
order to enable the respondent, extra copy furnished
Bibliography.
within a period of 1.
Obliged.
Because your lordship. Here, my lord, pursuant to a sale notice, my lord, published in the daily newspaper, my lord, the petitioner, there was a sale for mortgage as assets of erstwhile MS Sonar Kachar publication. The petitioner offered to purchase the same, my lord, and his offer was accepted, my lord, being the highest bidder, my lord. Accordingly, possession certificate was also given to him, annexure C, my lord, at page 21 and 22, my lord. But subsequently, my lord, registration has not yet been made. So because of this, my lord, not giving the my lord, registration, my lord, making the registration, the petitioner is unable to utilize the property, my lord. And he is facing heavy loss, my lord. Because
Who's to give the registration?
the AIDC, my lord. Your lordship may kindly see annexure D at page 24, my lord. This is the letter made by the petitioner whereby a request was made. Page 24, annexure E, my lord. With reference to the subject mentioned above, I so and so, purchaser of the assets of erstwhile so and so, do agree to carry out the registration in my name. Kindly provide the necessary permission to carry out the registration process from the office of AIDS and also appoint an authorized person to carry out the same. So subsequently, a reminder was also given by the petitioner. Nothing was done, and legal notice was also served, my lord, but they remained silent, my lord. The petitioner made the complete payment, my lord.
Yeah,
Yes, ma'am. I'll obtain instruction, madam.
your board,
AIDC, madam.
pre-ID,
AIDC.
with the board,
In the
Fine, this is the part.
mortgage, assets, erstwhile, solar, Kachar, property. In terms of state. Right. Right. You responded or registered. Third what? Sale.
Register, yes, ma'am. Yes,
Where have you stayed?
my lord, registration of the, my lord, process, of the, my lord,
Where, which paragraph?
at page, my lord, paragraph, my lord. Para 4, my lord. Therefore, my lord, after, my lord, the purchase, the petitioner, my lord, the petitioner,
Sale being made. Responded that not registered. You know, it's
My lord.
Right. Council or other extra copies of the- We listed on.
Highly obliged.
May I please, Lord? Well, in this case, my lord, my lord petitioners, my lord, one katha land was, my lord, taken by the, my lord, health department lordship by promising to, my lord, appoint, my lord, against two grade 4 court lordship. My lord, subsequently, my lord, instead of one katha lordship, 1 biga has been recorded in the, my lord, revenue records. Now the petitioner submitted application to correct the revenue records. My lord, that is not done yet, lordship. On the other hand, my lord, appointment, my lord, by promising which lordship the land was taken, lordship, that is not yet considered, lordship. My lord, the petitioner's prayer is, my lord, to correct the, my lord, record of rights, lordship, and to, my lord, pay compensation for utilizing their land, his
Where
land.
is that agreement that you pay?
Agreement, verbal agreement, lordship.
How can we issue orders on verbal agreement?
My lord, the notice may go,
Why notice to decide what?
my lord, in similar case, lordship, the Istanbul court, my lord, has directed to pay compensation, lordship. I have annexed that order, lordship. At page 44, lordship. Exactly similar case, lordship. Government can take the property, my lord, without paying any compensation, without process, lordship.
There is a reference of a resolution been taken by the public. In page 44, there is a reference to a resolution.
My lord, resolution, my lord, nothing is there, lordship. I have no resolution, man. Even if there is no,
I don't know, it is reflected in the order that there is a resolution. In your case, where is the resolution?
my lord, resolution is not there, lordship. Nothing.
How can
My lord,
how can
I
the-
verbal.
I don't think there any direction be issued that pay compensation. Who
Then, my
said-
lord, what is the stand of the government, my
where
lord?
is the- where is your claim to show that this land belongs to you? That-
Yes, lordship, I have sold it, lordship. My lord, kindly see the page 15, lordship, registered sold it.
15,
Page 15, 1/5, lordship. This is that, my lord, original vernacular is at page 17, lordship.
where is the Jamapati, is it there?
Yes, sir, Zamamandi is also there, lordship. Annexure 2 is the Zamamandi, page 23. My lord, 1 biga is recorded in the name of, my lord, civil hospital, lordship. In favor of, my lord, Bunialguri Subcenter, Health Subcenter, lordship. My lord, kindly see, my lord, page 38, a certificate issued by the, my lord, HDM and health officer, lordship. Page 38, lordship. My lord, 13 land of 13 persons were taken, my lord. The petitioner's name is, lordship, at the serial number. Second, lordship. Page 38.
What is the name? Read it out.
Saheb Ali, lordship. Herein, my lord, it is stated half biga, lordship. Not 1 katha, not 1 biga, lordship. It is also stated in the certificate that the land was taken, my lord.
Heard,
Mm.
by of payment of compensation. Meeting. Part of that. Subcenter. What subcenter? Medical
Yes, Bunyalguri Health Subcenter, Lordship. This is under public.
health subcenter. Objects the other list of list of the owners issued by the SDM and H of campus here. Name of the petitioner is and it shown that petitioner has taken the part of the land. Notwithstanding that, the claim for intervention has not been addressed by the information has been filed. Same has not been addressed. The grievance has not been fixed. One, three,
1, 3, and 4.
year on. Five, six. Our extra condition.
How like that?
The petitioners are the owners and possessors of a land which was purchased by their father in the year 1969, 67, Your Lordship. Thereafter, they have been possessing the land, paying revenue till 2011. However, from 2017, 2015, when they went to pay the revenue, the authorities have informed that there is no land recorded in their name. They're still in their possession. It perhaps happened due to change in the circle and creation of BTC in that area, Your Lordship. So till date, the land records are not traced out by the revenue authorities. We have filed legal notices and there are reminders as well.
You filed before the concerned DC.
Yes, Your Lord, filed. The DC has forwarded it to the circle officer twice, but no action has been done after that. The last forwarding letter is at page 82 and extra 15. It was forwarded by to the circle officer by the.
You have the revenue board.
Lordship, there is no record as such, Your Lordship. We have prayed for furnishing at least a record also. That is also not furnished. Only we are verbally informed there is no land recorded in the name of the father. We have the Jamabandi as well as the sale deed, Your Lordship. We have annexed it here. But they could not trace out anything as regards to them.
Legal years of one the year 1967. Passed in the year 1975. Possessing the land. Why do you say suit land? Is there any suit pending?
No, no, Lord.
Huh?
No.
But you referred to it the suit land.
It's mistaken type. Land.
Submitted that pay the land revenue and pay the land revenue 2011 and when they approached the authorities to pay the land revenue and you paid their name right, the relevant records could not be placed out and the authorities refused and refused tribal status of the are they may be evicted.
Yes. 1, 2, 5 and 3.
Here on behalf of 1, 2,
5 and 3. my lord.
1, 5 and 6. For the government. Suresh Sharma, six. Rabha, still.
Well, in 14, I am
There is
for
a
the
request to
petitioner, my lord.
RBC, my lord. There is a request.
Well, I am for the
Yeah.
petitioner, my lord.
Yeah.
My lord, it is a GST matter, my lord. I am assailing the notice issued in page number, my lord, 30, DRC 01.
Page 30.
Page 30, my lord.
Yes.
My lord, first of all, my lord, the notice date is 29/9/2023, my lord. My lord, 2023, my lord, there is a judgment of this court, my lord, the Guwahati High Court, my lord, in the case of Maina Devi Chorodia, my lord, versus Union of
Yes.
India. Whereof, my lord, this notice, extension of notice, my friend to hand over the copy of the set of the judgments.
No, first tell us your case. What are the facts involved in the case?
I'm relying upon, my lord. The fact is, my lord, I'm coming one by one, my lord, in short summary, my lord. There was a notice issued under, which is annexed in page number 30, my lord. The
Yes.
summary notice, my lord, which Mr. Jatin Hajai in the morning, my lord, argued on the same matter, my lord. Scrutiny of return for the, my lord, this is a scrutiny of return for the period 17-18 months. My first point, in extension to Mr. Hajai's argument is the scrutiny of the return under section for the period 17-18 falls under section 61 of the GST Act. If your lordship takes up 61 of the GST Act,
61. You're referring to section
61, my lord.
61. 61.
61, my lord. 61.
Yes.
The proper, I am reading it out, my lord. The proper officer may scrutinize the return and related particular furnished by the related person to verify the correctness of the return and inform him of the discrepancies noticed, if any, in such manner as may be prescribed, and seek his explanation thereof. 61 is Rule 99.
Yes.
Rule 99 prescribes a notice to be issued. Scrutiny of return, Rule 99, where a return furnished by a registered person is selected for scrutiny, the proper officer shall scrutinize the same in accordance with the provision of section 61 with reference to the information available within. And in case of any discrepancy, he shall issue a notice to the said person in form ASMT 10. My first point of argument is no such notice in ASMT 10 was issued upon me.
Okay.
My lord, as because it was not, when no notice was issued upon as per Rule 99, my lord, directly a notice in DRC 01, which is the so-called notice to be issued under Rule 142, Sub-Rule 1BA, my lord, was issued upon me. my lord, the second point of argument is that the summary notice, my lord, which was issued, does not suffice the notice to be issued into as per DRC 01. Malad, this was argued at length. I'm not taking your lordship time, my lord, argued at length by Mr. Jatin Hajai, my lord, same summary of notice, so-called notice, my lord. It cannot substitute the notice of so-called, my lord, in DRC 01.
So you are saying your submission is that the, prior to issuance of the summary of notice,
my lord,
under 142, there must be a proper notice issued. Under
my
290.
lord, along with, my lord, not prior, along, my lord. The
Along.
word over there was along.
Okay.
My lord, thereafter, my lord, lordship comes down to, my lord, page number, my lord, the reply which I've adduced, my lord, in page number 39, my lord. Lordship, come, my lord. Page number 39
Of the writ petition.
of the writ, my lord.
Yes.
Petition, my lord. Page number 39, my lord. My lord, column number 7, my lord, lordship comes, my lord. Column number 7, my lord. Whereof option for personal hearing I have ticked it. Yes.
Yes.
Lordship, come, my lord.
Page 39.
39, my lord.
Yes.
In the box, my lord, serial number 7. Option for personal hearing, my lord.
Yes.
I have ticked it. Yes, I have sought for a personal hearing, my lord. Now, what the law says, my lord, section 75 of the Act, my lord.
Yes.
Section 75 of the GST Act, my lord, 75(4).
Yes.
My lord, an opportunity of hearing shall be granted where a request is received in writing from a person chargeable with tax or penalty, my lord. Thereafter, my lord, or where any adverse decision is contemplated against such person. Even I do not seek for a hearing, a personal hearing, my lord. In that case, also the proper officer has to give me an opportunity of hearing, my lord. In this case, my lord, no opportunity has been given to me, my lord. This was my third argument, my lord. My lord, thereafter, my lord, in page number 40, my lord, of my writ petition, my lord.
Yes.
My lord, in page number 40, if your lordship comes up, my lord, the second paragraph, the company wishes to, my lord.
Yes.
My lord, the company wishes to bring to your attention that the above summary has been issued under section 73 of the Assam Goods and Service Tax Act 2017, my lord, and rule 142 of the Assam Goods and Service Tax 17, my lord, without issuing a so-called notice to the company in the first phase. My lord, this was my first contention, my lord, in the reply, challenging the so-called notice issued, my lord. Thereafter, my lord, in the last one paragraph, my lord, placing emphasis on the above and with reference to the case of Vishwakarma Industries versus State of Jharkhand, my lord, which Mr. Jatin Hajai has, my lord, a few minutes ago, my lord, laid down before your lordship, my lord. The taxpayer wishes to state that the summary so-called notice issued under GST DRC does not substitute the requirement of a proper so-called notice required to be issued under subsection 17 of the GST Act, my lord. One of the next page, my lord, 41, my lord. This is my contention, my lord, which I have raised against the so-called notice issued, my lord. And none of this contention has been dealt with by the concerned officer, my lord, who has issued upon me the final order, my lord. My lord, page number 41, my lord, paragraph number 2, my lord, from the above. It is settled principle of law that where a power is required to be exercised by a certain authority in certain way, it should be exercised in that way only or not at all. And all other modes of performing are necessarily forbidden. Therefore, GST DRC which was issued against me without the issuance of ASMD 10, my lord, as per Rule 99. I have contended over there, my lord. Thereafter, the next paragraph, my lord.
So where is the final order? Where is the
My lord,
order?
the final order is in page number, my lord. It starts from page number 43, my lord.
43.
43. In fact, my lord, page number 45 is the. It starts from 43. 45 is the main. My lord, in spite of I objecting to the nail, my lord, against the so-called notice that it is bad in law. In page number 45, your lordship comes, my lord, from the boxes given thereafter, my lord, response to the taxpayer is agreed. But I've never agreed upon this. The taxpayer agreed on the following amount in the SCN. I have never agreed on that. My lord, not a single line has been written that I am agreeing to that. My lord, thereafter, my lord, page number 46 again, my lord. The very top line, the taxpayer has agreed to the following amount in the SCN. My lord, never, my lord. Let the respondent show it that I have accepted in the reply to the so-called notice that the tax is to be paid. My lord, and my last, my lord, argument, before that, my lord, all the notices are unsigned. All the notices are unsigned, my lord. And before concluding, my lord, I'll request my colleague, my lord, to hand over the index of the judgment I'm relying upon, my lord.
Yes.
My lord, the very first judgment, Manak Devi Chorodia, my lord, of Guwahati High Court one. My lord, page number 3, my lord, in inner page number 3, my lord, and paragraph number 2, my lord. By filing this writ petition under section Article 266 of the Constitution of India, the petitioner has assailed the notification number 9 of 2023 CT dated. I have also, my lord, in this petition, my lord, I have also assailed the notification, my lord. By virtue of this, which the time limit provided under section 7310 of the CGST Act for the financial year 1718, 1819, 1920 was respectively enhanced from this. It is projected that a time limit in respect of the petitioner for examining the annual return for the financial year this has expired on 31/12/23. However, on the strength of the impugned notification dated 31/3/23, so-called notices was issued to the petitioner for the financial year 1819. In my case was 1718, my lord. And accordingly, the said notification has been challenged inter alia on the ground that the condition precedent providing in explanation to section 168A was not present in the on the date where the notification was issued. My lord, lordship takes up, my lord, section 168A, my lord, once, my lord.
So you're referring this judgment for what purpose?
My lord, I say, my lord, it is barred by limitation. I say that the notice, that the order or the notice in DRC 1 and the order subsequently, my lord, following, my lord, 168A, my lord. Notwithstanding anything contained in this act, the government may, on the recommendation of the council by notification, extend the time limit specified in or prescribed or notified under this act in respect of action which cannot be completed of complied with the force majeure.
Yes.
And my lord, many courts, my lord, following this, my lord, judgment, my lord, many courts has already passed order, whereof, my lord, it has been admitted, my lord, for exchange of affidavits.
Yes.
Thereof, my lord, summing up, my lord, my first argument was 168A, which, according to me, my lord, the extension is not permitted as per the provision of law, my lord. Thereafter, section 61, my lord, the notice was not issued. Thereafter, 75(4), my lord, whereof the personal hearing was not given. Thereafter, the orders were not signed, my lord, and Mr. Hajai's argument as regards to the issuance of notice without any proper notice, issuance of a summary of the so-called notice.
What is your first argument again?
These 5 points,
What is your first argument?
my lord.
Your
My
first,
first argument, my lord, 168A, my lord.
so essentially you are saying that this is not the
Force
ground.
majeure, my lord. The condition does not exist to implement or extend the date under the section 168A, my lord.
Yes. Mr. Chaos.
Similar order has been passed and we filed one affidavit in WPC number 1299/2024. That will cover all the cases, Lordship.
When is it matter fixed?
Today some matter has been fixed and I'll.
Item number 6, your lordship has heard this. That
No,
my
no.
learned senior was referring to item number 6, but that is also almost similar thing.
No, no. The
Lordship, with regard to the force measure, on the basis of the force measure notification, Lordship, these assessments are being made. Some of the items are listed before your Lordship today. And where my senior colleague has filed one affidavit. And for the state Lordship, we are yet to receive the instruction.
Where is the demand notice?
My lord, page number, my lord, demand notice is in page number, my lord, 43, my lord.
The demand amount is at page 48, not down below, 12,81,020. Page number 48 is the demand, not down below. Yes, madam. Summary of the demand. Page 48, down below, madam, right hand side, 12,81,026.
Your name, please.
Well, Sandeep Churaria, my lord.
Mr. Sandeep Choraria, learned counsel appearing. The petitioner is agreed by the impugned order dated. What is the date of the order?
19/12/23, my lord.
19/12/2023, which was issued against the petitioner raising demand. One 28/1026. Which includes the tax liability along with interest and penalty. The demand is raised for which periods? 2017.
17/18, my lord.
17. It is submitted that to begin with, this demand raised is time barred in terms of section 168 capital A. And no reasons for extension of limitation has been given by the respondent authorities. So
Well, exists, my lord.
no reasons exist. So the further submission of the learned counsel to the petitioner is that notices, in response to the notices that we have received, he had filed a reply giving details of the taxes he has already paid and as to why the demand is not justified. Stop. However, in the impugned order, in the summary of the order, impugned order, it is reflected that the petitioner has agreed to the show cause notice, which is totally contrary to the facts and the records available. Further submission, council is that no show cause notice was issued along with the summary of show cause notice issued. And this is contrary to the mandatory provisions of the act and the rules. What was your fourth submission?
Well, a personal hearing was not given as per section 75, subsection 4,
The personal hearing included under the
short
act
for.
was, although sought for, was never given to the writ petition. Stop. Accordingly, it is submitted that the impugned order needs to be interfered with and set aside, and the same is contrary to the provisions of the GST Act of Mr. Ezekiel, the Standing Council GST, along with Mr. Standing Council State GST, submits that at this stage notice be issued that they be permitted to obtain required instructions. It is submitted that in a similar matter, it is submitted by Mr. KM that in a similar matter, an affidavit has been filed
In WPC number 1229/2024.
in WPC number 1229/24.
24.
So let the matters be listed again on 12th of June. Enabling the respondent counsels to obtain and complete their instructions in the matter. Since the standing councils have already entered appearances, notices are waived, our extra copies be furnished within the period of this week. Within the course of this week. Stop. Notice issued. Is there any stay prayer?
My lord,
We'll issue notice at this stage. We'll decide on your stay prayer on the next date. Since your demand is.
I'll be open for course of action, my lord.
No, but this, the demand was made way back in 23.
But 23, my lord, but it is against the principle of natural justice and without jurisdiction, my lord.
That's all right. We'll look into it, but we are issuing.
But
notice
at least a
that-
verbal, my lord, instruction upon them not to take any course of action, my lord. Otherwise, I'll
Issue notice on.
when
the
an
impugned
infatuous petition will be
prayer,
infatuous.
returnable on the same date. Till the next returnable date. No coercive action be taken against the writ petition in pursuance to the impugned order. The notice.
Same, 15.
Grateful, my lord.
Same.
15 is same.
Item 15 is same with the show cause notices at page
Let the
45.
matter be listed on 12th of June. Item number
15 minute, the next.
15, my lord.
15.
One.
All right.
My lord, no, only the date of the order will be changing, my lord, to 9th of December 2023, my lord.
9 December 2023 in item 15.
15.
In item 15, my lord.
Item 15, 9 December 2020.
The
My
demand
lord,
is
one point which I've agitated, my lord, has not been considered by lordship, my lord. The issuance of notice, my lord, as regards to the scrutiny of the return has not been issued upon me.
Tomorrow also.
The further submission of the council is that in this is required under section
My lord, section 61, my lord.
61 read with rule 142.
Rule 99.
Section 61 read with rule 299. That as per the provisions, the notice required has not been served on the writ petition.
Grateful,
Yes.
lordship. Grateful, lordship.
Yes.
May I please, Lordship? Lordship, state GST authorities had passed an order against which I have already preferred an appeal. Now, for the same period, Lordship, the CGST authorities have passed an order. The impugned order in this petition, Lordship.
I think there was a matter last week.
Yes,
Lordship.
Lordship.
Similar nature.
Yes, Lordship.
What order was passed?
Lordship, earlier it was, the order was state. And now we have to come with the clarification which authority will continue with.
Lordship, if I may please submit. The impugned order has been passed in this case by the CGST authorities. The impugned order date is 15/12/23, Lordship. This order deals with two assessment years, 2017-18 and 2018-19. So far as 17-18 is concerned, Lordship, those similar orders of extension notification 168A, 17-18, those will apply, Lordship. As regard 18-19, Lordship, those 16-4 orders which your Lordship has been passing, that it is pending at Supreme Court, that will apply, Lordship. And at the same time, there is one more submission that in view of the orders having been passed by the state GST authorities and appeal having been preferred by the SSC, so the order passed by CGST may require to be set aside, Lordship. These are the only submissions, Lordship.
I heard current counsel for the
Lordship, here multiple cause of action has been clubbed together.
Only one order has been challenged.
No, that is correct, but Lordship, Lordship may come to page 37, their prayer. The premises aforesaid it is not seriously prayed, your Lordship may be pleased to issue call for the record. Mandabus, number 1, holding that the notification 9 of so that is 168A. Then 2, to issue writ of certiorari and other appropriate causing setting aside the so-called notice dated 16/2/2023 and order dated 15/12/2023 issued by the respondent.
Proposed notice issued in pursuance of
the
notification.
consequential prayers.
No,
Yes,
Lordship,
consequential.
but what my learned friend submitted, that one is 116.4 and one is extension notification under section 168A.
Also, they have passed a common order on both the grounds. I am challenging that one order. I am not challenging multiple orders.
Where is that order?
The order is at page, Lordship, 143.
Heard current counsel for the parties, petitioner is aggrieved by the dated 15/12/2023 issued by the respondent. Nothing.
Oh.
In 3/2022, by which the following order was passed, page number 157. Expect you.
Hold on, Shriman, put it on.
134.
Take our order and finish it on that.
Page 157. So, it is submitted that this is otherwise, it is the time barred assessment.
Lordship,
The
for
time barred
17-18.
For the assessment year 17-18, but the claim was the period of limitation was extended under the notification
Number 9.
number 9 of 2023 issued by the authorities of CTST dated 31. It is submitted that the extension of limitation under the state notification is contrary to the provisions of section 168A, the CTST Act 2017. The such circumstances, the authorities could not have issued the show cause notice and passed the impugned order. So it therefore submits that the order be set aside and during currency of the retribution, required interim orders be issued. That Mr. SCKL appearing for the central GST and Mr. P. Chaudhary appearing state GST submit that there is no infirmity in issuing the impugned order as the same is permissible in terms of the notification dated 9 of 2023 issued under section 168. Now, what happened? Both have initiated action.
Lordship, here they have challenged our order only. Against that, they said that they preferred appeal. That prayer is not there.
The appeal petition is at page 221, Lordship, against the state order, which is not the subject matter of this petition.
Where is this state order?
The state order, Lordship, is at page 217, Lordship. has been passed on 8/12/23.
217.
Lordship.
Same adjustment here. The state authorities have also issued an order under section 73, which is dated 8/12/2023.
The appeal is at page 221, Lordship.
Then why are you praying for setting aside of this 16 to 15/12 order?
Lordship, 15/12 is the order passed by the CGST authorities for the same period.
Against which there is an appeal,
No, against the state order, there is an appeal,
not against the CGS.
not against the CGST order, Lordship.
Appeal lies, but he has not preferred the appeal.
Because of the challenge to the notification, Lordship.
You say that in the same issue, state GST has also invoked its jurisdiction and has passed the order dated 8/12/2023, against which presently an appeal is pending. So, and the counsel for the petitioner that since the notification dated notification number 9 of 2023 dated 31/3/2023 has been put to challenge in the present proceeding, the petitioner submits that there is no other alternative. The remedy of an appeal prescribed in statute would not be an adequate remedy. Therefore, the petition is filed. Let the respondents complete their instructions and file necessary affidavit. Meantime, till the next returnable date, no coercive action be initiated against the detention. It will be listed on 12,
Lordship, along with WPC 1229/2020.
along with WPC 1,
1229.
1229
23.
2020.
24. I'll supply copy of my land at friend.
1229. This is a wave explanation. Yes.
Matter relates to petitioners where the hospital teams for 2023 lordship, some excess amount were collected from the petitioner's lordship. In this regard, they have submitted representation for refunding of the excess amount. Similar situated person also approached the honorable court earlier lordship. There is an order.
What order?
To dispose of the representation of the petitioner.
Who for the respondent? A refund of airfare.
Yeah, those collected.
There is
that
a
amount.
council has submitted the order passed by coordinate bench. Please go through and let us know. We'll take it up after a while.
My lord, in this matter, name is not shown, the copy is not also served to us, not only deputy CGI, SGI is there, my lord. Item 18.
What about the number 3?
2 and 3.
You have not served copies on the union.
Union I have submitted.
Please call your counterpart. Please inform your counterpart. CGC. We'll take it up after a while. Yes.
May I please, Lordship? Lordship, GST Act was implemented with effect from 1st of July 2017. Those purchases which were made by the SSCs before 1st of July 2017, Lordship, taxes were paid upon such purchases. For claiming input of such purchases, there was a facility of claiming transitional credit. Form Tran 1 had to be filed. Accordingly, the petitioner had filed the Form Tran 1, Lordship. But the notice was issued calling upon the petitioner to produce the invoices under which he had made purchases. But the petitioner could only survive for 3 months under the GST regime, which is July, August, and September. Subsequently, their business operations got closed and the registration got cancelled. So the show cause notices was never served upon the petitioner, Lordship. All the invoices are available with me. I have attached with the petition. If I'm given a chance by setting aside the order and before the adjudicating authority, I can produce all the invoices again, Lordship.
Lordship, first, the order is applicable order. Secondly, Lordship, we come to page 53. Page 53, paragraph 3.
Yes.
The said notice was asked to so cause as to file A, central tax amounting to rupees so and so only should not be demanded and recovered from the petitioner, then B, applicable interest, then C, penalty, then clause 4. The said notice did not submit written submission on demand some so cause notice date so and so, then 5, Lordship. That that taxpayer was given chance to be heard before the executing authority at letter dated 17/10/2023, 6/10/23, 7/11/23, and 21/11/23 via speed post and through email to their principal place of business. But the notice neither appeared nor given dates nor submitted any written submission.
Lordship, page 39 will be relevant.
Then principle of naturality was followed before passing the MP note order.
Page 39 will be relevant. Lordship. Page 39 is the profile of the petitioner on the GST portal, which says that the registration was cancelled by the district authorities effective from 12th of April 2021. And the order which Learned Council has just now pointed out is 27/12/23. So since the business operations were closed, Lordship, I am coming with all the invoices and I just need a chance to prove that
You
I
did
have.
not appear.
Lordship, my business operations was closed. I did not get any notice, did no communication. They never contacted me. I just need a chance to
I'll produce the entire
invoices.
original records, Lordship, allow some time, whether notice was served on him or not.
All right. Heard learning from. Where date? 27/12.
Lordship.
Right. Yes, it. Nine values, 76,000. Penalty of the same amount.
Yes, sir.
Not same amount,
No.
Lordship, 10%. 10% of the tax amount, Lordship.
And a penalty of 10% of the tax. Oh. Petitioner had earlier carried on the earlier tax regime and post EMC GST regime. The petitioner continued for a few months and thereafter put up business after about 3 years. When did you wind up your business? In
Lordship, business operations were closed in later part of 2017, but registration got cancelled in 21.
you submitted that prior to the appeal order being passed, this is that we should state it to everything whenever received the petition. Given an opportunity to like place case before the authorities and duly supported with all adequate invoices. So we have submitted that. Since the business of the retention, there was no intimation from the respondent authority. So Mr. S. set up Mr. S. Gap and standing out the GST subject like for the record and origin verify. Place before the court. Not verified, place before the court. And support is contented that due notice was served on the retention. View of such submission with the matter be listed on
On 13th.
13th.
Until then, Lordship, no course action.
13th of June 2020. This order was passed in December.
Lordship, I was never informed because I am not
That's
there
all
at the
right.
address. I am not there at the
Therefore,
address,
interim
Lordship.
order will be considered on the next date fixed, based on 30th.
There is one more submission, Lordship. The GST portal is not allowing me to file an appeal. It just may be observed.
Because it must be typed, but
No, not time, but Lordship. They say there are some earlier rules. They will remove my statutory right of appeal. So it just might be
pick
recorded.
it up. The next date, let the record.
Oblige, Lordship. Notice on interim relief also.
Yes. Yes, Mr. Roy,
Lordship, notice may be similar.
have you seen this order?
Yes, Lordship has shown me Lordship last. That can be passed, Lordship, verifying this.
Right, yes.
My lord, in this case, what had happened is that the petitioner's wife, 8-year-old son, and the brothers, they were picked up from the road by the police personnel of the Udalguri police station on 8th of May 2024. Thereafter, they were detained in the police station for 5 hours, and then having found nothing incriminating in the vehicle, my lord, they were released. Now, interestingly, they have detained the vehicle of the petitioner. There is no case registered against the petitioner. There is no formal seizure list prepared. The vehicle is lying under the open sky in the police station, my lord. So, my lord, for release of the vehicle, I have filed this writ petition. I have no other alternative remedy. I cannot go for Jimma petition also, my lord, because there is no case registered, my lord. Neither there is any seizure list. I have made that statement at para 4, my lord. Will see page 5, para 4. Page 5, para 4.
Yes, madam, get your instruction.
Yes, my lord. I have to obtain instruction whether any case has been registered.
Heard by the council. Petitioner is agreed by seizure of his vehicle, hearing registration number, what?
Registration number AS01
Where have you stated?
Para 3, my lord.
para 3.
Any documents enclosed?
Yes, my lord. The RC registration certificate, the insurance, pollution certificate, everything included.
What is the number?
Number is AS01 EY 7556.
So. There is no case registered against the petitioner, but the case has been the vehicle has come with by the station. Left with no alternative. And therefore, the governor will obtain instruction. Okay. Council to complete the instruction. Let extra copies be furnished within the course of the week. Matter will be listed after 1 week.
My lord, a fixed date may be given.
14th.
14th. I am deeply obliged.
Obliged.
Not 14th.
In this case, Lordship, will pay
case lordship regarding ceiling lordship. There was made lordship certain area of land was taken as a ceiling surplus land lordship that was in the year 1976. That was beyond the knowledge of the petitioners and their predecessors. Subsequently, lordship, when 2022, when they went to record their name as a legal heir, they came to know that land has been made as ceiling surplus. Thereafter, we filed an application before the revenue authority, and subsequently, lordship, some verification report, etc., has been submitted. Lordship, if your lordship kindly come to page 23. This is the report regarding present status of the land. And, my application has not been disposed of. That is page 17. And the report is not.
Find out, get the status, what is, find out why this application is pending. Let the standing council, PTC.
Madam, application is.
Application before the government. Revenue disaster management.
It is pending where?
Before the government revenue department. Case 17.
Revenue department.
My lord.
Who's for revenue? Secretary.
My lord, secretary.
Yes, madam. MS here on standing council. Department of Revenue will obtain instructions as status of the petition stated to have been filed. Okay. The copy be furnished, they expect to get. Still after marking.
Obliged.
May I plead?
Yes.
Before I take your lordship to the pleading, the matter, the crux of the matter is very short. It's like this, my lord. First, the petitioner's wife. What you? I am extremely sorry. I'm what meant?
This is regarding settlement of land, my lord. The SPLSA meeting already approved the proposal, my lord, at page 24, my lord. Page 24. Starting from page 22, my lord. Resolution number 26, my lord. The settlement proposal of golf cast land measuring on cut of 5 less are covered by the number so. Meeting in favor of petitioner, my lord. Thereafter, my lord, the HDO civil, my lord, page 29, my lord, forwarded a letter to the deputy commissioner for necessary action, my lord, page 29. But the same is pending till date, my lord, page 29.
Yes, madam, get instruction.
Yes, my lord.
Let the governor get and step on. State instruction. As to whether the representation by the right. The copy is established on the governor. Yes, sir.
2 weeks may be granted.
2 weeks.
Yes. It's from the beginning.
Obviously.
In fact,
Don't-
you also may note one more thing, my lord. Yesterday I was going through again the file. Also, see page 32.
Yes.
The C form number is mentioned, my lord,
Yes.
in line 2.
Yes.
Now I also see the, I given the copy of the C form. The type copy, original copy, I'm submitting page 36.
Yes.
This is the C form, my lord. This is, has been generated, my lord, online. And you'll also see at page 38. Annexure A. You'll also got to
38, page 38.
38, Annexure A, transaction details in relation to Form C, that is number so and so.
No. What is this number?
The C form number, madam. And the C form number mentioned in the notice is altogether different. I'm giving the original copy, madam, photostat copy of the original. Idea. At page 3, you'll also see. And also just compare it with the page 32. So you'll also see, my lord, at page 1 of the C form.
Yes.
The first line, my lord. The form is generated is so and so based on information received from the issuing dealer and the details. So this form which I submitted earlier, my lord, that this was generated online and not procured from the office, which the Haryana authority says that somebody has procured fraudulently. That is also not correct.
No, what we want to know is, according to you, the transactions are covered by page 38.
Yes, my lord.
Between you and the dealer in Haryana,
My lord.
the whatever transactions took place is covered by 38.
My lord.
And in the notice, what is being mentioned, page 32,
The C form received
the
from so and so.
C form uh, has got nothing to do with the transactions at page 38.
Well, what I was submitting that, my lord, even the C form number which they have mentioned, that has been declared to be obsolete. That is not the C form, because the C form which has been issued, which I have annexed in the petition, the number is altogether different.
No, that's right. So,
Hello.
according to you, the C form which has been declared obsolete,
Said to be declared.
said to be obsolete, is with regard to a transaction which did not occur with you.
Which is not covered by my C form. And if your lordship sees a fit in opposition, the Haryana letter, my lord, page 9.
Yes.
Respectfully, you notice that some person fraudulently has obtained C form from this office, showing purchases so and so. what I was showing to you, Lordship, my lord, the question of procuring the C form from the office probably does not arise. Because it was generated online by the procedure.
No, but
And secondly, the C form number,
assuming this letter is correct,
my lord.
we'll take it that it is correct because it has come from a state authority. Page number 9, the affidavit. So, assuming this is correct, then this C form does not pertain to the transactions between you
Would
and
you
me.
mention, my lord, your lordship, may see the mentioned C form number?
Same number
Same number, my lord,
as in 32.
my lord. SRN number OGC, which is not the number of the C form. Now, my lord, your lordship is saying, my lord, that assuming this is a state letter and it is presumed to correct, then prima facie, my lord, this was not procured from the office. Assuming, my lord, the C form numbers, I take it for the argument's sake, the C form numbers are the same. But when the C form has been generated online, how they can say that somebody procured the C form fraudulently from the office? This is also not correct. On both these scores, it is not correct. I'm going on the larger issues without going into technical issues. He was supposed to take a step whether the assessment has been completed or not.
My lord, we have received our instructions, my lord. It was dated 31st of May, issued by Joint Commissioner of Taxes, my lord. May I produce before this honorable court, my lord?
So, the fact remains that the assessment has not been completed. This matter relates to 1718, and we are in 2024.
So that's it. That it is factually, they have stated in their instructions that they
Not
have not
completed. They have not made the assessment. And if they have not made the assessment, then the notice cannot be issued for demand, because the notice can be issued only after the completion of the assessment.
What do you say with regard to this?
This is the instruction that we have received, my lord.
If the notice goes thereafter, if they have the time limit, they may, whatever they may do.
My lord, Mr. B. Gogoi is appearing for this matter. He is on legs, my lord, in another court, my lord.
We also only wanted to know about the instruction whether assessment has been completed or not.
Okay. Is he available in the second half?
Yes, my lord.
Dr. Saraf, we just hear what he has to say of this instructions at 2 p.m. At 2 p.m. Ask him to come at 2 p.m.
My lord.
Nobody.
25 and 26 may be taken up after, so I have to file my affidavit. There is one more matter. Patient. Here, Lordship, I pray for some time to file my affidavit. 24 and 25. 25 and
You have produced the contract agreement.
No, it was not. We have completed the work and as per MES rules, we have deposited in the department. As per their process. And condition 37 is enclosed and please refer respondent page number 8 of the petition, sir, Your Lord. Or the respondent has
Anyway, notice has been issued under
Yeah.
11.6.
Yes.
I heard. Who's for the respondent?
I am for this. Really, not airport. Garrison engineer.
the commander of engineer and garrison engineer. These are the two respondents. Accepting officer is commander
You
of
are
engineer.
appearing for all.
All.
Pursuant to the order dated 3/5/2024, issuing notice. There is a notice note dated 31/5/2020 stating that the petitioner did not take steps on the respondents. However, given the matter is called, Mr. S. Roy, on behalf of respondent 1, 3, and 4. He submits that he requires he prays for
4 weeks time, Lord.
4 weeks, 3 weeks time.
3 weeks.
By his
Your Lordship, please give me a specific date in the last month of June. We are on the contractor, so we have to move on the side.
uh, matter be listed on 27th.
Lordship. Lordship. There is one more matter, Lord.
Similar order.
Lordship.
You are appearing for all.
All, Lordship. In 26, similar and one arbitration petition, 10 of 2024 may be tagged together.
It is submitted that these two matters be listed on 27 along with arbitration petition 10 of 2024. Arising out of, is it the same contract or
Yes,
different
sir.
contract?
Different contract, but the respondents are all the same.
Filed with the same petition. To be listed on 27. 27.
Lord. Obliged, Lord.
Yes.
Before I take your lordship to the pleading, the crux of the matter is very short. It happened like this, my lord. Petitioner's wife, petitioner number 1's wife, actually during Holi, what we call Fakua, some club members intruded to her place and outraged her modesty. An FIR was filed, which eventually a circuit was filed against the club members. And the trial is now, after framing of such, trial is going on. That happened in the holy days, the Fakua days. In the, that is called Durga Puja time, my lord. The Durga Puja time, the club members who were otherwise politically influential, I'll tell the short
synopsis, exactly what happened. They demanded 50,000 rupees from me as a donation to the Durga Puja of the club. And I, having a grocery shop, I refused it. Then in that next Kali Puja, they brought one lady from 75 kilometers away, filed an FIR against me, the petitioner, saying that I have committed 376D, me and my brother-in-law. Therefore, an FIR was filed. 376 was registered. Then, fortunately, my lord, what happened? I had the video footage and the pen drive. I went to the police station saying that I want to give it. Police refused it. I went to SP. SP says go and settle with the IO. Then, my lord, I filed a writ petition. The High Honorable Court asked them to give a status report. Notice was issued. During moment they got the notice, they came to me saying that we will accept the video footage now. That is now practically that part is solved. What has happened? FIR was filed in 5th of November 2023. Your Lordship was very much aware. 2009, section 173, subsection 1A was brought in, saying that if an offense under 376D is registered, it is an obligation, the word shall is on the part of the IO to finish the investigation within 2 months from the receipt of the information. And the detailed procedure is given. Even your Lordship also will be aware that our court in a PIL so motor matters, 2 matters, directed the Director General of Police and others that complete it. I am not saying today that I should be exonerated. Now, what has happened? Every day I go and ask that please do something about my case. I am not for exoneration. Complete it, file a search sheet or do something. Now they have taken the video footage. Now my limited prayer today is, in terms of section 173 1A, may I have point out the section? Second copy of the CRPC that was introduced in 2009. One 1A was brought in most probably in 2009, if my collection is correct.
Yes.
It subsection 1 says every investigation under this chapter shall be completed without unnecessary delay. 1A was brought in. The investigation in relation to an offense under 376, 376A, B, C, and D, as your Lordship got. 376D, my case, gang rape, and E of the Indian Penal Code shall be completed within 2 months from the date on which the information was recorded by the officer in charge of the police station. Then what is to be done? Now my limited prayer today is, I am not asking for exoneration. After that, my lord, the PIL also, in the suo motu PIL, 2 judgments came out from this High Court. May I copy? In this also, I have gone through it, a statement from the bar. Director General, even the Advocate General also appeared, saying that this will be taken care of, all these cases. Now, I am limiting myself that as a result of a pendency, your Lordship will be realized that as a result of pendency of a 376 on my head, what has happened, my business reputation in the grocery shop and in the town, my lord, this is a big thing. I am saying that let them complete it, let them file a search sheet or final report, that whatever they want to do. Because already 7 months have gone, not any iota of investigation. That much will do fine. Let them do, let them file a search sheet against me also, I'm happy. Let them file a FIR, whatever is there. Because in the town area, small town, 376 by a lady of 75 kilometers away, he comes at the behest of the. This much is my prayer. I am not asking for any other reason.
It's a 376D case, Lordship, and it's a non-bailable offense, and they are evading arrest. So we are unable to complete the investigation. That is the report, the comments we have received, Lord.
They have not cooperated.
No.
You're not
not on bail.
I have the
Most
copy.
probably they have not,
They wrote a letter. I personally went and handed over the photo video.
no.
What? I have the
Sorry.
copy. I just the copy. Can you get it? Most probably that record is not. What the video record?
You call for the case record and have a look.
That's because we have received that pen drive from the family members. Along with thereafter, we have
Yes.
asked for the hard disk. That was also provided to us, but they are evading the arrest.
These are the
Most
copies.
probably the bail application that was rejected because of that lordship. Now, by this way, they wanted to.
What is, yeah, are you on bail?
My lord, I have, in fact, what happened, I had to come to the High Court asking them to seize my things so that I can appear and give it to them. They refuse. Ultimately, after High Court notice, they have taken this, wrote a letter to me and I have handed over.
You appear before the authority, we'll direct them. You appear and
Well, what?
you appear before the authority.
Appear. Huh? Bail apply করবে তো।
Let them apply for bail. If the bail is granted, they will. Because of that, I think this writ petition.
Well,
It's not
huh?
their submission that they want bail.
No,
Say
lordship,
that
as
it has
because
to
they
be
have not yet get the bail.
My
That
prayer
is
was
why by
that I
that
will-
way.
Now today the question of arrest has come. My prayer was I may be directed so that I can go and hand over things. Moment they got a notice, they wrote a letter, I went and handed over. Today a new dimension has come that I am not cooperating. There's a new dimension. Now that was not the statement that why they are not accepting the video footage. Ultimately, I said that you take the video footage. If you find me guilty, then you arrest me or do something.
Video footage is one of the material.
One of the material.
So they may have like to have some other
Any other
material.
material. So correct.
So if you are insisting on completion of the case, the
Right.
investigation, we can issue a direction, you go and appear before the IO on a fixed date.
If you go, arrest to the bail করবো না।
In that case, that
I may submit my amount of within 1 month I will appear.
We'll fix a date.
Huh? At a date. Oh,
We'll fix a date.
my lord. At a date.
and police will proceed in accordance with law.
And also, my lord, police will proceed keeping in mind the provision of 173(1)(a). Because our PIL, that orders also have come, that police has to give a search sheet and write everything if somebody is not cooperating. And but let there be a search sheet or anything.
That's because the pen drive along with the hard disk that was provided by the wife of the petitioner. That is the instruction we have.
The club members, one case after another. First, they have been search sheeted for outraging my wife's modesty. Then a demand of 50,000 rupees come from the club members on the pretext of Durga Puja. Himantari, please. My lord, I'm told that 30th June he will go and appear and may have the indulgence. My lord. Let the police also follow the procedure contemplated under 173(1)(a).
Yes.
Hmm?
There is a difficulty, lordship. If that direction is given, if they are not with the handle of that bail from this court,
I didn't get it. Sorry.
lordship, if the direction is given to them that to appear before the IO on 30th, and without a bail order, they will be arrested, lordship. As because 376D, it's a
For them to worry.
yes, lord.
That is the law.
That
is for them to
that
worry.
no, lordship. When there is an order from this honorable court directing them to appear before the IO, then IO will proceed in accordance with law. That part.
That's what I am
Lordship.
Not preventing you.
Including 173(1).
But there must be a finding by the IO as to whether his custody is
Yes.
necessary or
Lordship,
not.
yes.
All these will have to.
Yes. As because the FSL report, I have also received some materials are there. I do not want to disclose it as because it's not a bail application.
third Mr. K. Pathak, assisted by Mr. J.U. Laswal, J.U. Laws. Petitioner is before this court. Limited prayer that the investigation relating to the what is the case number?
Case number was, my lord.
105.
2105 of 2023. Hilchar PSK.
2105. Silchar PS case number 105 of 2023 under section
342
slash
Lordship.
346 slash 376 within bracket B, the Indian Penal be completed in terms of the mandate of section 173 within bracket 1 capital A of the CRPC. The Honored Legal Counsel submit that because of some incident which took place between the petitioner and some other person, LP, a false allegation was made by the against the petitioner and his brother-in-law by lodging the instant FIR. It was registered as case number 2. It is submitted that the investigations in respect of offences alleged to have been committed under 376D capital D inter alia are required to be completed within a period of 2 months from the date on which the information was recorded by the officer in charge. And the senior counsel submits that this is the mandate of section 173 within bracket 1 capital A of the CRPC. So, however, notwithstanding the FIR being registered on
5th of November.
On 5th of November 2023, till date, the investigations are not being completed and no charge sheet or slash or final report has been filed by the IU. So, the petitioner has handed over CCTV footages available with him in support of his
Along with the pen drive.
along with in a pen drive along in support of his contentions that he's in no way connected with the aforesaid allegation of this is gang rape, is it?
They said it is gang rape. And they said
376D is gang rape.
that was
2 persons.
that lady from 75 kilometers away.
Not connected with the allegations made in under section 376 capital B. So, notwithstanding that petitioner has approached the IU, but no steps have been taken by the IU to complete the same investigation in terms of the mandate of 173 within bracket 173 capital within bracket 1 capital A, the CRPC. So, it submitted that because of dependency of the FIR, the petitioner has lost his credibility and status in the society, and that has affected his business, which is his livelihood. So, he therefore has approached this court. He therefore all his efforts to request the officers concerned to complete the proceedings expeditiously in terms of the mandate of section 171 capital A has evoked no response. He has accordingly approached this court direction to the respondent, or more particular, the officer in charge of the section police station to complete the investigation as per the mandate of section 173. Para Mr. H. Sharma, that senior, additional senior governor.
1 to 5.
Submits their own instructions received from the IO. Submits that it is the petitioner who has not cooperated with the investigation and because of which the investigation could not be completed. So submits that if the petitioner appears to the IO, then the proper investigations can be completed and the matter can be brought to its logical end. Having heard learned counsel for the petitioner, considering the limited prayer made by the petitioner, this petition stands disposed of with a direction that the petitioner will positively appear before IO Signature Station on
30th June.
on 30th June is a Sunday.
Sorry. 29th of June.
29th of June. On 29th of June, before the IO. At 10 a.m. At 10 a.m. So the IO Signature Police Station, and in his absence, the officer in charge will ensure that all statements and materials which are all statements be recorded of the petitioner and the investigation be proceeded with in terms of section 173 1 capital A as per and read with the other provisions of CRPC. So the respondent authorities, more particularly the IO, directed to complete the investigation in terms of section 173 capital 1A within the period of 2 months from the date when the petitioner has been directed to appear before the IO. Petition according.
And yeah, Lordship, the IO will proceed in accordance with law. Otherwise, Lordship.
The IO will proceed. IO is permitted. The IO will have liberty to proceed in the investigation as per the provisions of.
Otherwise, also he is duty bound to proceed according to
No,
law.
Lordship. Otherwise, without there being a bail order, Lordship, with the handle of this order.
How can that be?
Yes, Lordship.
Where is the
Let us not
mandate
use the
that
word
he appears
handle.
before the court and he appears before the IO and he has to be taken into custody? Where is the mandate?
That mandate is not there,
Not
Lordship. But when there is it's a non-bailable offense, Lordship.
Whatever it may be. So whatever
When
steps
there is
he
a
has to take
non-bailable offense, without there being an order from this honorable court, Lordship, it's difficult on the part of the
Same was
IO.
discussing that PIL matter. And only I actually don't actually have some reservation about using the word handle.
I'm sorry, Lordship. With that
Handle,
word,
they will use it as a handle for the some of things.
I'm sorry,
Court's
Lordship.
order should never be used as a handle. I'm obliged to your Lordship.
Your adversary is trying to find reasons for your prayer.
But the word sometimes.
Because it's that Kamakra corridor case, your lordship had fixed it for interim prayers. We've also had an additional affidavit, in fact, addressing the query that has come from your lordship as to the agency and the nature of the survey. So there may not be so much time at the end. I mean, subject to your lordship's convenience, of course. 3:30, whenever. I'm here with us through the day. Very well. I'll be here. Very well. I'm great.
That written instruction I have placed. So Lordship will grant us that liberty to go for the body assessment. Because of the pendency, we could not proceed. Lordship name.
There is a stay, is it?
There's
Stay of the
some
notice
interim.
only, not assessment proceedings.
Even then, it is subsidies here.
Very well, then we'll we keep it for 11 or
Well, on 14, it will be on 14.
14th.
11th for my lord.
Pass order.
Your lordship may reserve it, my lord.
Don't want to reserve it. That's the only-
Man on 14th. man.
14 now, nothing is there.
No,
Court
that's
directed judgment.
What is wrong in 11?
Let's say 11.
The 11th, you can request one of your colleagues.
Only the court will judgment, dictate the judgment.
Lordship.
Only thing, my lord, my learned friend said that liberty to proceed with the audit assessment, that your lordship cannot grant.
Will not grant them liberty to proceed.
Proceed in accordance with law.
As per provision of law.
My lord, that may
Whatever is
proceed,
permitted.
anybody, nobody stop.
Yes.
They can,
Only thing, my lord, so far as the my lord, C forms are concerned, but without making any, my lord, any observation on that point, only on this impugn order, and the notice, my lord. Lordship will interfere only on.
no, how we,
You be present when we dictate the order.
Lordship.
the whatever we have submitted, the cancellation, all things have been argued.
On
Okay.
11th,
11th for judgment, my lord, dictation.
it will not be listed for judgment, it will be listed for admission, but will dictate order.
My lord.
At 2 p.m. It's on 11. 11 for admission.
In this case, I have received instruction. The notice was issued as a protective demand. And my instruction that they will not proceed with the MP notice. And there is a judgment, final judgment is 24th Honorable Supreme Court. So I have received, I could not place today. But my instruction is that we are not proceeding with the MP notice.
Lordship may kindly go through the show cause notice
There
one.
is an interim order already.
Yes, it is there. And we are not proceeding further with the MP notice. This is my instruction.
Lordship may kindly go through the show cause notice once at page 190.
Then Lordship, it may be educated. If my learned friend is insisting that it may be educated, I may be allowed to file my
Lordship, I'm just saying, Lordship, I'm just submitting that in case his submission is that the matter will be taken up with the Supreme Court, then Lordship, I don't have any problem.
I've submitted that we are not proceeding with the impugn notice because this is only issued in as a protective demand laws.
Why?
Because
Do you have
Lordship,
anything in writing?
I've received a writing today, Lordship, I could not brought. I'll place tomorrow, Lordship.
Wednesday? We'll give it on Wednesday. You want to place it before the court?
Yes, Lordship.
Lordship. Mr. Dayal, studied on the topics. He has received instructions that willing to proceed on the demand. Impugn demand. He, however, topics that you'd like to place the required instructions.
Written.
Voting.
Lordship. Lordship, the interim order may kindly.
Interim order.
Obliged, Lordship.
Lordship, item number 29 to 46. This is the matter relating to where notification under section 181 challenge. We have filed our affidavit in WPC 1229/24. I pray that may be taken along with this matter, and the state is yet to file their response.
They, my lord, Lordship will take up after 4 weeks.
Right.
In the meantime, we will file a affidavit.
No, what have you challenged here?
Lordship, that force measure extension notification case is.
Question of law.
Yes,
Lordship, but along with
We
that,
have fixed matters on 12. 12th
yes,
of June.
2 matters have been fixed.
So we'll take it up, all these matters on 12.
no, but Lordship, the service of affidavit has to be completed. We also need to file a reply.
My lord, on 12, my lord, those matters can be clubbed along with these cases, my lord. Today, date is given, my lord.
Today itself, I'll supply copy to my landlord.
Where is your affidavit?
In Lordship in WPC 1299/24. Item number 29 to 46.
So these matters can come up after vacation, Lordship.
I have not listed today, please. That it is not listed today.
Yes, it is, that is not in the list today, Lord. 1299 is not today. Lord.
When is it picked?
Lordship, probably there is no.
It is submitted by learned studying council. PhD, let's say, yeah, and an affidavit has been filed in WPC
99 24.
of 2020. Submits that the environment agency said affidavit will cover stand of the department in respect of all the of the petition, the said petition, however, is not listed. Its KL is permitted to supply copies of the affidavit, the respective council of the petition within the course of the week, so that the respondent may supply the respondent within the course of the week. Let all these matters be listed again on 12. Let us see on 12.
Not
Meanwhile, you supply the
today itself I'll supply.
hard copy, soft copy, whatever it can supply.
I'm supplying hard copies.
Hard copies?
Yes.
Not soft copy. All right. Mr. D. Saraf and
I will supply the list, Lordship. Item numbers.
Mr. Misra. Supply the
My prayer, my lord, to
and
some
Mr.
time to file it.
B. Gogoi, crave leave to file affidavit. Yeah. And MSK Fuban for Union of India.
There will be one more issue, Lordship. These affidavits will be on law point, but in each and every fact, there are varied facts also. If they don't want to agitate,
How do you know you have not been served with a copy?
common affidavit, they are telling
I
like.
don't know.
Lordship.
Go through, find out.
Lordship. Oblige, Lordship.
Thank you.
You are responded. This side. In this matter, my lord, I was supposed to place instruction regarding asset handover, my lord, order. But I have received sort of instruction, my lord. According to which, my lord, it was handed over on 1/8/2023. But so far as petitioner is concerned, my lord, he has said that there is some other assets also there which is yet to be handed over, my lord, for which executive magistrate has to be redebuted for the task, my lord. That position I don't know yet, my lord, but petitioner counsel was last time also absent, this time also absent, my lord.
Your Lordship, I am for the
Respondent.
respondent, number 5 actually.
There.
The company, what happened is actually,
No,
Uh,
the petitioner is not here. What is the point?
yeah, petitioner last date also there, no.
None appears for the writ petition. Matter being called as M. Burman, a governor, state of Assam. And your name, please?
IS Majumdar,
I.S. Majumdar appears for
respondent for respondent
5.
5.
5 and 5. And who's 6 and 7?
Yes, sir.
For 5, 6 and 7.
5, 6 and 7.
Yes, for 5. Matter be listed up.
Problem. Instruction may be kept on record, my lord. Or I have to produce next statement.
You produce on the next thing. We'll hand you back the.
My
I'm appealing for respondent number 1.
Nobody for petition.
On last occasion, report was called for from the police.
None appears for the petitioner on call as well as the state. MS
MSF Hussain.
F, say it. Private respondent.
Yes, Your Lordship.
Respondent,
Number one.
matter be listed after the,
Date may be fixed, Your Lordship.
No.
Oblige, Your Lordship.
come after.
Oblige.
Maybe Lordship. Lordship kindly pass over the matter for a day. My lord, the counsel for the petitioner could not come today.
The request made on behalf of. Who's for the petition? You are for the petition.
S. Bora, my lord.
The request is made on behalf of MS S. Bora. Council is not present in court. It will be listed out in 1 week.
My lord, deeply honored.
Service not complete. Notice office note shows that my lord, notice issued to the respondent on 10/5/24. Private respondent.
Yes.
Issuance of true death certificate. First wife, my lord, was my lord divorced by civil order. Declaration order, my lord.
Yes, madam, any instruction?
I have received the instructions today only, Lordship. So I'll file my affidavit. 2 weeks time may be gone.
Planning council held subjects that she had received instruction. Right. They have made it not objected to by the council. Petitioner is after 2 weeks.
Obliged, Lordship.
I've not read your lordship's list correctly.
Before my learned friends starts, Lordship, we are supposed to file an affidavit. In this case, the Kamakya corridors case.
Sorry, there's one more matter. One more matter.
Oh, sorry. 15. Well, oh, my lord, I'm sorry. Jump.
Yes.
May I last it? My lord, I have got a plot of land over which I wanted to construct my half building, ground plus 2, with the due permission of the GMC. Then, my lord, the army authority
For
came and said
CGC,
that,
who's
my lord,
for CGC?
my lord, the other side said coming. And on last day, he wanted to take some instruction
Correct.
on my affidavit in reply. She said that in the meantime, I had applied for the permission for the GMDA. They said that no operation certificate is required from the military authority and asked me to apply before the GMD. And I applied before the GMD, and GMD has recommended that the permission can be considered. That since the area is a residential area, the restriction imposed may not be applicable in that area. So this, the other side will be able to pay. She verbally told me that at least 2 weeks time may be required for consideration of my application.
They're not here.
For the timing, please coming. I am calling. This.
So far as GMD is concerned, Lordship, after they return the file, Lordship, to approach another authority,
In the month of April, we wrote a letter seeking permission for issuing the building permission. And we have not received any reply from their side.
Side.
Army.
Army.
Lord. Army. Yeah, the provision is that the
So
army.
let the CTC be called for, because
Yes, I am calling.
some
For kindly,
instructions were required to be obtained.
Yes, Lord. Yes. For the-
Yes.
We have filed an additional affidavit at page 242. Your Lordship said last time raised a query, what is the nature of the survey and what kind of authority can do it? Mimula's got a brief write-up signed by the former Director National Institute of Hydrology, which is at page 248. The affidavit.
Yes.
248. I will read it out because everything he says is of relevance. I, Sudhir Tomar, former Director, National Institute of Hydrology, Roorkee, have come to know that there is a proposal to redevelop and beautify the area around Ma Kamakya Temple, Guwahati. I have stayed at Guwahati for 2 years during 1992 and have visited the shrine a number of times. Ma Kamakya Temple is one of the oldest Pitha in Assam and is spiritually considered as one of the most sacred places in Northeast India. Over the years, surrounding areas, the temple has witnessed civic expansion, which has resulted in unintended growth in the neighborhood. The existing service infrastructure is stressed to cater to the growing influx of pilgrims. To address the arising infrastructural issues and beautification of the temple area, the government of Assam has prepared a redevelopment plan for the area. In this regard, it is to apprise that the Ma Kamakya temple is situated on top of an isolated hill about 270 meters above mean sea level (MSL). The hill is composed of granitic gneiss. Groundwater in granite gneiss flows only through fractured joints. Any construction activity may disturb the flow path of the spring water. Therefore, given the large-scale construction, including multi-level buildings, it would not only be appropriate, but essential to conduct a comprehensive geohydrological study of the hill, so that the spring supplying the water to the Garbhagriha area is not disturbed. This study needs to involve subsurface mapping using ground-penetrating radar around each temple with water in the sanctum or Garbhagriha. This will help to detect joints, fractures through which the water is flowing into the sanctum and also flowing out. Fractures joints are also present all across the hill, which is the reason why there are also water tanks spoons. Their source of water might also be through fractures joints, for which ground-penetrating radar survey around these spoons is also necessary. A multi-pronged approach will be necessary since it is proposed to engage an agency like Geological Survey of India for carrying out the study. Ground-penetrating radar is a non-invasive study. Basically, they do it through electromagnetic radiation, and they ascertain the nature of the rocks, sediment, and what is there underneath. And also importantly, your Lordship will know, this temple has had 2000 years of construction. From the 4th to the 10th century, there was the Varman dynasty. 11th and 12th, there was the Pala dynasty. 13 to 16 was the Kots. Then 15 to 18 overlapping was the Ahom. So there's been construction over all this period. So the Geological Survey of India has in fact carried out a survey of the Ajanta Ellora cave, which your Lordship find at 249, a news report. Your Lordship, page 249, second paragraph. This is a news report which is of 13th of December 2008. We got it from the net. But they've done seminal work there. There's a book written on it. Paragraph 2, I will read. The GSI, this is quoting the Director General of the GSI. The GSI is the nodal agency for addressing social issues related to geology like arsenic pollution in the belly of the earth, landslides affecting human life, earthquake resistance construction, etc. That's the GS, Director General. As the GSI has several branches all over the country, Maharashtra branches have been working in various regions of Western Ghats, Nanded, Nashik, Ajanta Lairan, who names some, Tejal Singh. Of late, the GSI has been working on preservation of the old paintings in the caves of Ajanta Ellora. The paintings have been done on stone and are getting destroyed because of water percolation in the cave, something like that. In collaboration with the Architectural Survey of India, the GSI surveyed the area and detected the source of water. We have now blocked the water source, and work is on to fill the fractures in the cave. This is being done with Japanese monetary aid. He added, what factors are prevalent there, what we need to be therefore taken into account is that he added that excess heat is another factor responsible for the sorry state of the cave painting, and hence measures have been taken to ensure that the exposure to heat is minimized. Only 10 people are allowed to enter the caves at a time now. The lights inside the cave are cold lights, that is, they do not emanate heat. The vehicular traffic leading up to the caves has also been restricted. Now, at page 51, if your lordship will come, I want to show, because this is very important, what is presently happening in Kamakya. This is the Siddheshwar temple, Siddheshwar Shiva temple. This temple is, as your lordship enters the main, after the multi-story parking, and there is the parking to the left, which goes down. And the right, which goes, leads to the stairs climbing to the Bagalamukhi temple. This is the Siddheshwar temple. About 30 years ago, there was some construction there. What happened is the inflow of water is not interrupted, the outflow is interrupted. So if a lordship sees 251, what I have encircled in reds are pipes, because we cannot take photographs or any videography of the inside is not permitted. So therefore, the pipes shown in the red circles are used to pump water out of the Garbhagriha of Siddheshwar Mandir, since the outflow of water from the natural underground streams has been blocked due to ambient construction. So it is not that we do not have a precedent, there is already an existing precedent. And the next page is the same thing. So, my lords, as it fell from your lordships on the last hearing, that who and what kind of a survey? This ground penetrating radar survey is what was opined as the National Institute of Hydrology. He was posted here, so he knew about the temple. Would be the most relevant and geological survey of India, which is the Government of India organization. We today have not.
What the survey reveal?
Ground penetrating. That is what he says, in the notes. Fractures, if your lordship will see. Page 248. Can I take a lordship lecture?
Okay, I understand fracture.
Fractures and what is set out in bold in page 248 is what he has said. The lordship has 248. What?
But according to the learned advocate, in the temple complex, there is no construction within the temple premise.
And the construction will be done by removing the existing commercial buildings and some of the residential buildings. Already these buildings are there, hotels are there, commercial shops are there. We are removing and making it open space. And there will be steps. And the other day it was submitted that there will be multi-story construction. The multi-story lifts will be there using the slope. There will be no building as such. Everything I will explain. Lordship, let my friend complete.
This is all what he's saying across the bar. What is the construction? What is the construction being envisaged? As your lordship gets into the main Kamakya temple complex, to the right is Chinnamasta and Kameshwaranath to the right. Then your lordship goes. What they is there from the plan, which is below the 198, 200, is that they are going to flatten it and make it at various levels. From the existing 3,000 square feet, it is going to go up to 100,000 square feet. Now these sacred underground springs are all interconnected. It is not that it is all, that the spring is Swayambhu only in Malod's in Kamakya, in the main Garbhagriha of Kamakya temple, and then it's only there. It comes from elsewhere. We don't even know where it is. It comes from, it goes to the Tara temple. It may come from the Dakshina Kali, and then to the left. So it is all interconnected. So if you are going to build between these temples, obviously it is going to be built there. There has to be disruption there. There's no question of no disruption being there. If you are building 5 multi-levels, the lifts may be on the sides of the slope, but then you will have to have retaining walls. Detention, page 200, what my learned friend was saying at page 200 in the writ petition. They have already said there are going to be digging, etc. If I remember. You also come to the writ petition, which I showed to your lordship last time, which is that page 199 is the brief particulars of work. Because this is for the tender for the EPC, 300 crores of brick, mortar and steel. 400 actually, 402 crores. $199, your lordship has the brief particulars of 200, which I showed to your lordship last time. And your lordship is quoted in the order. Your lordship may come to the bullet, which is development of site, where the detail is written. Development of site, your lordship has the
page number
200. Development of site, I think development of below lifts and escalators, development of site, temple road, pathway and parking work, temple entrance, gate, landscape and horticulture, planter with seating bench, RCC planter with skylight, stormwater drain, contour site soil cutting, filling, disposal,
retaining wall to counter level difference. So there will be different levels. So the Ma Tara temple will be one level, then the Kamakhya temple will be, so in between all these temples, there's going to be a retaining wall. So today we don't even know what is the hydrological mapping. And your lordship will see on the next page of 201. There are five flaws which are envisaged there at the bottom, table A. So it is just leaving the temple intact and saying that we are leaving that intact. It is not an idol here. If it had been an idol, nobody would have any issue. Today, the sacredness arises out of the geography. The sacredness arises out of the underground springs. If the underground springs connecting Dhumavati and Kamakhya are, because Kamakhya and Dhumavati are practically Dhumavati are one next to the other, one is below the other, and below that is Bhairavi. There is going to be construction there in between. There is going to be a leveling there. There is going to be a retention wall there. And it's 102 minutes. It's all there. Your lordship may see we've taken the video 102. It's all there. Model from the model itself. So we don't today. We cannot even decipher what is there because if your lordship sees between all these temples there is construction, there is digging. That is the difficulty. Who can have any objection to any renovation, beautification, for pilgrims being given better facility? Your lordship has 102 minutes.
Yeah.
What is the detail? If your lordship sees between all the temples, top right hand, I don't know what temple is there because we are strictly identified. The point is that between all these temples, at the top, I think maybe will be Kamakhya temple, then other one will be on something else. Then there is at the bottom, we have another temple here. So all of these temples, there is construction in between, which will entail digging. So today, when we go down to the Garbhagriha Ma Kamakhya, it will be barely 30 feet. So you are going to build 5 floors, so retention walls will be 100 feet. If it is there between Dhumavati, either Dhumavati dries up or Kamakhya dries out, there is no outlet from Kamakhya, Garbhagriha. Then you'll have to have water pumps to pump it out. I showed to your lordship the Siddheshwar temple. Because of ambient construction, that is right at the entrance of the hill. So a hydrological study is a prerequisite or compulsory. Without it, how can it be proceeded? The very sacredness of Kamakhya is from there.
And what study was conducted earlier prior to the?
They have to answer, but an RTI queries are not given any response. We don't know what if your lordship sees the tender at page 200 again, 199 minutes. All they say, you take clearances from municipal authorities. That's all. 200 minutes bottom. From what I read to your lordship will read the 2 paragraphs below. Liaisoning with statutory agencies like municipal fire services, AI, EIA, BSNL, for obtaining the pre-construction and post-construction clearances. Statutory payment to the agencies will be paid by the contractor, which is the scope of work, except the charges of HE electrical service from local so, which will initially be paid by the contractor and reimbursed by the department of contractor on producing proof of charges to local. Then your lordship will come to the last paragraph, obtaining mandatory approvals, pre and post construction from all local bodies, state and central authority, EIA, fire clearance, environmental impact. They will only look at what is the impact on the environment. We are today looking at the sacredness. This is entirely different. And then there was a 2,000-year-old history, 2,000 years of building. I have not been going to the archaeological component. Archaeological component is something that today, because even then, assuming that it is still necessary, which it isn't, because after all, this needs to be preserved. Today, this very sacredness is from the ritual springs, from the eternal springs. And I've shown wells from your Siddheshwar temple wells in the additional affidavit. They are pumping out the water from there. So without a geohydrological study, how can this?
What would the hydrological study establish?
Hydrological, as he says, to establish I will read out the 2 bullet points from the affidavit. Impact of the construction on those on the fractures. Water flows through fractures. 248. I will read the 2 bullet points at 248. subsurface mapping using ground penetrating radar around each temple with water in the sanctum or garbhagriha. This will help to detect joints, fractures to which the water is flowing in the sanctum and also flowing out. So it will show the flow of water. Fractures, joints are possibly present all across the hill, which is the reason why there are also water tanks, kuns. The source of water also might be through fractures, joints, for which GTR survey around these kuns is also necessary. So you have to preserve those also. The Saubhagya Kund, where the first where water is offered before taking darshan. That also has an inlet, that also has an outlet.
But without the hydrodynamic structures,
Please, Mullah.
as it said, there are several constructors, private, government, semi-government.
Yes, sir. Yes.
None of these constructors have
Because
hydrological study.
one construction next to Siddheshwar temple I showed to your lordship has already led to that water being disrupted. This is not in between in the main temple complex. This is on the side. On the sides, as your lordship, on the left hand side, basically what happens is one enters on the left hand side. There are all those houses which have been come on the left hand side. But there are apparently in the Bhairavi temple or some of the local people were saying that there is a disruption in the flow. Now, can we afford today to take a chance? I mean, what does it require? You're spending 400 crores. The very sacredness of Kamakhya is dependent on the eternal ritual spring. Are we now going to say that without a hydrological study was done, and so that for 2000 years what has been happening will go and then whole places loses its sanctity? Yeah, that's all.
We could not complete the filing process today because they refused to accept the affidavit. We served them because of waterlogging. We are a little bit late in filing the affidavit. We tried to serve a copy to the other side. They refused. So the process is not yet complete. Whatever queries Lordship is asking, we have every reply in our affidavit, number one. Number two, Lordship would kindly come to the prayer portion, page 40. Have Lordship got it? Page 40. First prayer is, certiorari shall not be issued, setting aside quashing the impugned notice dated 15/3/2024, that is regarding the construction. Then again, regarding the construction impugned notice. Then prayer number 3C at page 42, a writ in the nature of mandamus shall not be issued to the respondent authorities, particularly the Archaeological Survey of India, to forthwith pass necessary directions to declare the Kamakhya temple as an ancient monument of national importance by exercising power under Section 4 of the Ancient Monument Act 1958. And also the next prayer also, a writ in the nature of mandamus should not be issued directing the government of Assam, acting through the Director of Archaeology to India, to forthwith pass necessary direction to declare Ma Kamakhya Temple Complex as protected monument under Section 3 of the Assam Ancient Monuments and Records Act 1959. So far as prayer number A and B, these are more or less covered by the PIL, which is going on before the division bench. So far as prayer number C and D, they want a declaration or a direction to declare this Kamakhya temple under the Protected Monuments Act of 1957 as well as 58. For that purpose, can it be the role of the Honorable Court or us at this stage deliberating on this? If that direction is passed, the next day, government will have to take it over with an agreement, then Deputy Commissioner will become the owner. Not a single panda will be allowed to live there. Who is he? He is one single member of Bordeuri Homage. Today, who is running the Ma Kamakhya temple? It is the Bordeuri Homage. Is he coming here as a representative capacity? Is he representing the whole Panda community and the Bordeuri community? If that prayer is their lordship, in my humble submission, the necessary parties will be totally different and there will be totally different spectrum to consider this issue. I have gone through this, both the acts. Once that declaration is done,
In fact, in Maharashtra, there are several writ petitions where some temples were wanted to be brought under this act. In all the cases, the result was dismissal of those writ petitions because it is not the role of the honorable court also, as well as of the government straightway. Lot of stakeholders are there. As my friend is saying that the temple is 2000 years old. I fully agree. The Pandas and the Borderi Homas are also 2000 years old. Their whole legacy lies there. In that situation, if this act is brought and this monument is declared as a protected monument under the ancient monument of national importance under the act and the rules, as well as the state act, it will have a huge impact, huge public impact. So if they want to pursue that aspect, this is not the right forum. There has to be a lot of deliberations, lot of discussions, lot of stakeholders whose opinion has to be taken. It will be a huge public exercise. It cannot be decided in the court of law straight away. So if they want to pursue this prayer, C and D, Lordship, the other day, Lordship was trying to distinguish this prayer with the PL on the basis of these two prayers. The other prayers are already taken care of by the division bench. So why multiple cases? So that is a very big issue, Lordship. You will have to be in fact, if Borderi Homas comes, and today the Honorable Supreme Court says that Borderi Homas is running the Kamakhya temple in very good way, in a very proper manner. Deputy Commissioner is sometimes supplementing him, and everybody is happy there. That is the observation of the Honorable Supreme Court. Let me find it. That judgment is also there.
Paragraph 39.
So my friend agrees. So if prayer number C and D are allowed, his whole foundation will crumble. I mean, his whole foundation means the Borderi Homa's own ownership of the temple will go away. You are saying that this is self-destructive. Bail mujhe maar. This is a classic example for that. And I do not know what will happen to the single person who is before this honorable court. He belongs to the same community. So in that view of the matter, let them first clarify that issue. All the other issues regarding hydrological test, everything, these are in the pipeline, Lordship. All these things are being done in aid of the Indian Institute of Technology, Guwahati. So all these things, I have a direct reply. I'm not trying to take this honorable court to those aspects at this stage. First, let them clarify what exactly in their mind.
Apprehension.
Apprehension, Lordship, we are taking care in the division bench. Here also, in the affidavit, whatever apprehension they have, Lordship, my affidavit covers everything. That will satisfy this honorable court. I am very much confident on that. But that has not, it could not be filed completely, Lordship.
Take it up.
Yes, on maybe 16th or 17th, Lordship. On 17th, let them also go through it.
My learned friend just said that they are getting IIT Guwahati to, because today for now, we are not arguing the matter finally, the way learned advocate general is produced. Because they have not filed his affidavit, pleadings are not been there. So to say this prayer is maintainable, that prayer is maintainable for later. Today, as I indicated to your lordships, my pressing today urgency is that the water flow should remain intact, should not be disrupted. Now, as far as the geohydrological studies, and they are saying IIT Guwahati they are doing. Now, so then let them, because if they have said so, then let them indicate as on the next date as to what are the results of this.
Because that you refuse to accept the affidavit. Therefore, the filing.
Oh, I'm sorry, Milad. I've just 2 minutes ago, just before the
Not
hearing.
2 minutes ago, 1:45.
There.
1:45.
There you are.
Yes, 1:45.
He says that if you straight.
Yes, in
My learned friend told
1:45,
me
in
that-
1:20, 50, it could have been filed, and 2 o'clock, we would have made a mention before this honorable court to bring it on record.
So that I would have not read the affidavit.
No, we do not.
This is
That's
my learned friend is not.
No,
He said,
I'm
"Azim, I
not going
released
to
it."
argue on that affidavit.
When can you file it?
Let the matter come up on 17th, 18th, 17th plot. 17th, I think it's a holiday, maybe 21st.
But in the meantime, then the IIT
My
Guwahati
friend
study
will be
should
totally
proceeded-
surprised
the
what
hydrological
we-
study should be proceeded with. They should also indicate
No,
the results. Why not? Why not?
My friend does not know many things. That's why he is seeking.
Which is the
And let me explain what is hydrological test and study, Lordship. Now, all the restaurants, all the commercial places, and all the residential homes, they have pipes in their home, water pipes.
we have to clear everything. Then only the proper hydrological test can be done. Why I am saying that, Lordship, I have spoken to the proper scientific person. When the radar will be taking all these visuals, the water pipes at home will give a negative or will give a wrong impression. So therefore, first we have to clear everything, then this test can be permissible. Otherwise, what is a natural flow and what is an artificial flow, nobody will be able to distinguish straight away.
I hope he said so on affidavit.
I do not have to say all these things on it. I am not a,
No, I mean, what has been stated in the past, this is my primary concern.
my first submission is
This is something which as today being a member.
No, I do not. This is for just honorable court's consumption at this stage.
Oh. I don't know what is there in your affidavit. If the affidavit comes, then perhaps further.
One thing, Lordship, they have to segregate the pairs. If it is only on prayer C and D, definitely, Lordship, this petition is not maintainable at all.
We have kept the maintainable.
Yes. Okay.
No, today I'm not arguing the matter finally. In any case, when I was on section 15, this is also being done when I was to lead a lot of people.
We'll be more than happy to say that, Lordship, let the act be
Why
implemented.
should I give up my prayers now?
The government, on behalf of the government.
Satisfy your Lordship that the water flow is not disrupted. That is what I'm saying.
Lordship.
That is what needs to be done.
My friend is on a very narrow
only
scope.
concern. That is nothing else.
My friend is on a very micro level scope. What I am trying to give a proper macro level visual of the overall situation.
Let us have it on
19th, yes, Lordship.
or
20th to 0. Or maybe 21st.
Let your affidavit come. But meanwhile, what is to be done with your work order? You already.
Work order, Lordship. A lot of things are to be done. They themselves has written that no construction has started. They have stated. I have gone in the petition.
So
First, Lordship, not a single construction will take place till we clear the whole thing. After clearing, there are a lot of studies have to be done. Not only hydrological tests, there are other studies also. And the construction which is going to be done, Lordship, this is off the record, I am saying, that it will be on surface only. There will be no piling, nothing. All the hotels and commercial buildings there, they have pilings there. We'll be removing everything there.
So let us have it on 12.
Lordship, I am not available till 16th, 14th. I am not available till 14th.
Then on 10.
That's why I am saying, Lordship, 19th or 20th, whatever is convenient to the honor.
Your affidavit is not here. Once your affidavit comes,
yes, Malad.
whether they would like to file a reply or not.
Yes, Malad. Yes,
we may be called for, may not be called.
Yes.
Affidavit may.
No, Lordship, we are handing over the affidavit right now. If they want to file, in the meantime, they can file it. They don't have to get an order from the Honorable Court to give a reply. We are handing over the affidavit. Even if they refuse, we will give, Lordship.
So
or we will send it to the email. They cannot refuse an
You
email.
want it on 18th.
18th is, I think, Lordship, 19th could it be, Lord?
What is 19th?
Is it Wednesday or 21st, whatever is convenient?
Or Friday, whatever is convenient. The Wednesday.
19th.
In fact, Lordship, all the line departments were thoroughly discussed at 5 meetings at the central government level, at the PMO level, as well as the concerned department and cultural department of the central government, under which ASI comes. They were all part of all the discussions. They knew everything. Number one. Number two, the Honorable Prime Minister laid the foundation stone on 24th of February this year.
What was the finding of the consultative study?
Consultative study is still going on, Lordship. Construction will
But they
not.
awarded the contract.
We have awarded the contract for a different purpose, Lordship. We have to clear. For the studies also, the whole area has to be cleared first. What my learned friend is saying, that hydrological test or hydrological study. For that also, the area should be clean and clear.
No, your work order is on 15/3.
15/3 and 24/2, the Prime Minister laid the foundation stone of this project.
But it says
after all the studies, this was done.
And the work order says within 24 months. And there was a study prior to that. In fact, what my learned friend was reading out
This work order is for
2 years
the
for construction.
temple access corridor only.
Yes.
Temple access, yes, Lordship, but for that, there are two different aspects in our affidavit we have mentioned. Let Lordship go through the affidavit, everything will be cleared. The site plan are being prepared. On the basis of the site plan, some designs have to be done.
We just want to know what is this work order in respect of which work? Page 208.
208. Two zero 15-3 Lordship. 208, yes.
What is this work order?
It is on engineering, procurement and construction mode. So they have to do lot of things before the actual construction. The EPC construction mode.
What is the meaning of that? I'm trying to understand.
That is what Lordship, I also try to understand from them, what is this EPC? They said after clearing everything, they have to do all the tests. Therefore, if Lordship is pleased to come to page 200. Obtaining, last one, obtaining mandatory approvals pre and post construction shall from all bodies, etc. So once they cleared it, Lordship, unless clearing the commercial buildings which are already standing there. If suppose tomorrow.
That submission you are making.
Yes.
Is it available on some document to show that this tender initially is for clearing of these houses, hotels and all?
In our affidavit, Lordship will click it. I'll read that paragraph from my affidavit.
Because at page 199, in this brief particulars of the work, they say that they have.
That is why, Lordship, if it is regarding the construction, let the matter has to go to the division bench. If it is on the other aspect on the law point, then this matter can be considered by this honorable court for declaration of Kamakhya under the 2 acts of 1958 and 1959. There cannot be two parallel proceedings in the same court, Lordship.
You filed the affidavit?
I filed the affidavit, Lordship. And that clarification also, Lordship, may I just read it for Lordship's convenience?
Status of the PI?
Yeah, we have filed the affidavit. They took 3 weeks time to give a reply. So it will come maybe in 1 or 2 weeks time. May I read a very important paragraph? The deponent further respectfully begs to state that as many as 5 meetings had been held in the Ministry of Department of Northeastern Region, Finance and Economic Affairs Wing under the Government of India, Delhi, relating to the activities of the Empowered Inter-Ministerial Committee of PM Divine, in which the project in question, that is Ma Kamakhya Access Corridor, was mooted, discussed and approved. In the said meeting, various interdepartmental and the line department officials, including Department of Culture, were present, under which the Archaeological Survey comes. Further, while executing the project of Ma Kamakhya Access Corridor, any existing rules and norms shall not be violated. The deponent most humbly and sincerely undertakes before this honorable court that while executing the project work, statutory requirements shall be complied with and there shall be no tampering with the existing structure and monuments of the Kamakhya temple. It is also stated that decisions have been taken after discussion at various levels and no objection has been raised by any local residents. Only on the basis of hypothesis, the petitioners have shown concern as regard construction, demolition, etc. In fact, the bid document at Annexure K to the reply itself is very clear about the proposed construction. It is reiterated that the petitioner has approached the honorable court by making some baseless allegations and apprehension with an intention to stall the developmental activities for providing better pilgrim facilities to the peripheral area of the Ma Kamakhya shrine. The only work which is being sought to be undertaken by the state is developmental work for providing ease to access to the various devotees which come to offer their divine prayer in the temple complex. At present is in existence in a very haphazard and chaotic manner. It is further submitted that there is no decision taken by the state at this stage to even attempt to alter any of the temple complexes. Prior to issuance of the NIT and the notice to proceed,
A consultancy service was called for, and it is after in-depth study of the entire practice and ancient scriptures which are prevalent there, the state has decided to carefully chalk out the plan for carrying out the developmental activities under the central scheme called PM Divine. It is categorically stated that the project work will not impact the manner of worship and overall sacredness and uniqueness of the holy deity, and the project work in question has been undertaken by the respondents without touching any of the temples in and around the temple premise. The developmental work is proposed to be conducted after due publicity and detailed meetings, conferences held with representatives of Bordeuri Hamas and other government officials with the state administration at the highest level. However, no such objection at the relevant point of time was raised. In that view of the matter, the intention of the present petitioner of filing on the writ petition challenging the impugned order does not appear to be bona fide. The deponent states that the Ma Kamakya and other temples in the periphery are not declared archaeological sites. The project work has been undertaken by the respondent authorities in the greater public interest and therefore the personal interest of petition that we can skip. Now coming to the next. Paragraph 4. That before finalization of the project in question, it was discussed at various levels, including the meetings of Empowered Interministerial Committee of PM Divine Scheme, and the meetings were attended by officials of various departments. After threadbare discussion, the project was recommended and approved by the Empowered Interministerial Committee in its meeting held on 5/1/2024. Thereafter, the Deputy Secretary to the Government of India, Ministry of Donor, by official memorandum dated 16/1/2024, forwarded the minutes of the meeting dated 5/1/2024, wherein the state government was directed by the committee to award the work expeditiously. Now coming to next paragraph, paragraph 6. The deponent stated Assam Public Works Department has ensured a concept planning stage of Ma Kamakya Temple access corridor that no construction will be carried out within the premise of temple boundary as marked in the master plan attached. That attached word maybe we have wrongly given. It was not attached. If required, we'll place it, Lordship. It is to be mentioned here with that
Why don't you attach?
it is a huge one and very big size.
That is a soft copy of that.
Will definitely, Lordship. We do not want to hide anything. That is a very bulky thing. That's why we could not attach it.
Keep it ready.
In fact, yes, Lordship. The government of Assam is, because they have also given some from the Twitters also, but that is a much refined one now. The government of Assam is creating open spaces, covered corridors, and adding lift escalators for the convenience of the pilgrims, facilities for scenery, and also making it barrier-free for persons with disabilities on the slopes. There are slopes, Lordship. The proposal focuses on creating open space, pilgrim amenities, and facilities of required scale, and an all-weather access corridor for pilgrims along the periphery. As for the finalized conceptual site plan of the project, it has been clearly shown for creation more open space around the main Ma Kamakya temple, along with lesser ground coverage at temple entrance. On the basis of the finalized site plan, at present work on detailed design and working drawing is going on. So site plan has been finalized now, working plan is under process. And the same shall be sent to IIT Guwahati for structural vetting, and only after due diligence and approval, the construction work will commence. It is pertinent to state that IIT Guwahati, while scrutinizing the drawings, shall undertake hydrological and geological studies, which is mandatory in nature. No construction shall start until due clearance from IIT Guwahati is received, as well as from other relevant agencies are obtained. It is also worth stating that consent of established has already been obtained from the State Pollution Control Board. One permission has been granted, but for the other ones, lot of things has to be done before actual construction will start. So nothing.
Completely filing so that they can.
We have filed, Lordship.
We have asked them to complete the filing so
Yes.
that you can come up with a
Yes,
reply.
yes. And in fact, they can also then, because Milad, my only concern today, we are not for or against the project. I mean, it has to be for the project. Only is that the water flow should not be disturbed. That's all. Geohydrological study, because my learned friend has addressed every issue as to how my bona fides are lacking, etc., etc. I am not concerned because I am anyway a devotee. I have 1,000-year Milad history there, so I don't need to explain to you. But my point is that Yeah, since he says the geohydrological study, so if that is the only relevant part. Because he said the structural part of the geohydrological study.
Let the affidavit be on record.
Right.
Mr. Dari, like, company. Like, sorry, Learned Advocate General for the assisted by
I am appearing for R10,
our board or
phone number 10, the contractor.
so you're appearing for the contractor. Appearing for the private respondent.
Private.
Learned Advocate General that the affidavit not be filed. The filing of the affidavit will be it shows the court that filed within the course of the week.
Which one, Lordship?
Affidavit.
We have today itself. We are now. He will take it, and by 3 o'clock we will file it. 3 o'clock is the whole ending. It is already over, but we will file it today itself or tomorrow 10:30.
Are on 19th.
Let them also put in a response to my affidavit, because I was not tendered the affidavit. I did the additional affidavit.
Lordship, there are a lot of self-styled experts. We cannot respond to everybody.
Petitioners are at liberty by their rejoinder affidavit to advise the affidavit in opposition also filed by the state government. So is also the additional affidavit filed by the petitioners also taken on record.
Great.
The respondents are at liberty to respond to state affidavit. According to matter, we are not 19th.
And your lordship may keep the interim matters for next.
On also the point of maintainability, and I'd like to file a separate affidavit raising the issue of maintainability, my stand.
I'm ready.
Hello, let's look. Would it be on 21st, Lordship? Lot of cases are fixed on 2019. My friend is.
I can accommodate my learned friend this month. From next month onwards.
Online আছে না আপনার কি problem?
Or on 24th, 21st.
Very well, 24th Monday.
24th Lordship.
Oh, so therefore, we thought
Then
we would need 10, 20, or 11.
Then let it be on 19th. 19th.
We can have it on 18th.
18th Lordship, I am not here, Guwahati. And 24th also I am not here, but in between I am here. 19, no difficulty.
Great. Great.
Hello.
Or we can, any date after 24th, it's all right, but that's not the
Last week, Lordship.
No, I think let it be whatever they can have. Great.
Yes, any instructions?
Yes, Lordship, now as the GMDA had sent one letter to the authorities, and in view of that, Lordship, which we have received on 28th of March, and now a committee has been convened and they are looking after the matter, whether he could be granted the permission or.
Bring it on record, whatever you want to.
This is only parawise comments. So let it be come up after 2 weeks. In the meantime, if any development is there by the committee, Lordship, that is what I have.
Comprising of?
Committee of Lordship, as per our contention is that the no objection has to be moved through the GMDA. GMDA sent it to the office on 25th April, which we have received on 16 May 2024. GMDA requested to the respondent defense lordship to examine and give necessary security clearance for building permission of the petitioner. Accordingly, a board of officers has been convened, files so and so dated 28th May 2024, and action is in hand on the same. So now they will take care of whether the security clearance could be given to build his house or build his to construct his building, lordship. Because it is near the defense land.
Committee comprising of members?
Members are officers of army.
Only army.
Army.
is submitted by the learners P. Sharma on instructions that presently the NOC, the NOC to be
NOC,
granted.
NOC.
Yes.
NOC, but be granted. The question of grant issuance of an NOC is presently under consideration of a committee which has been constituted to look into the prayers of the petitioner. So, as per the instruction, the committee is seized of the matter, and the council therefore submits the matter be listed after 2 weeks.
Okay.
Write report about the status of any decision taken by yesterday by the learned council. You by the learned
The date may kindly be fixed
council. After
after
24th,